Item number 1.
None appears dismissed.
Weekly list, old matter, item number 2.
This case, this writ appeal was actually heard on merits. Both sides were heard and comprehensive judgment was passed. But subsequently it transpired that the appellant was dead by the time the appeal was pending. And there was a substitution petition, but it was overlooked. So no order could be passed in the substitution. Matter went up to the Supreme Court and thereafter the review court said that since the death occurred during the pendency of the appeal, it will go back to the filing of the substitution petition. The substitution in this case is 187 of 2012. Actually, the matter was heard on merits, but this was overlooked that the substitution petition was pending.
So it's only for this purpose.
Yes, bro.
So no, does notice have to go or any objection?
No, I am the appellant. As I am the appellant, I have appeared. So substitution has to be allowed.
No, any objection?
Yes, I am, your lordship, kindly see, though application was filed, it was not brought to the notice of the court.
That's right.
And this honorable court passes the order. Matter went to the Supreme Court. Supreme Court has said you file a review petition, bringing the matter to the notice. And after Millard, the writ appeal, the review petition is allowed. Now the position, Millard, the application which was already filed and record what was not taken into account, now it has they have to take steps to bringing the LRs and record. That they have to follow order 22 rule 3.1.
So you are objecting to this?
Yes, I am appearing for the respondent.
So what do you want to do?
No, the question is, had it been a case where no step would have been taken and
No,
Legal.
this is a 2012 application. Only when the review petition was heard.
Only on the point, Millard, that I have made this submission before the review court. Review court said we'll keep it open. That submission be made before the writ appeal. Here, Millard, I have given a note, 3 decisions. It has to be brought.
I have filed.
No, kindly. I am item 2 of that Millard flag mark your lordship kindly see. 1-page judgment of the Supreme Court. Accordingly, last paragraph.
All right. So they anyway permitted that appellant to file applications.
Yes, application for setting aside abatement, limitation and everything, all the petition. That is required under order.
No, this application is retreat. It's already a pending application.
Substitution petition was filed. Millard, that was on the record. LRs are not brought on a record. They have to be brought on record. That's why, Millard.
So why don't we allow this application? LRs will be brought on record.
Yes, the LRs are brought and they have to file necessary applications.
What more? This is already an application.
That means your lordship kindly see last paragraph.
Yeah. The application is already there.
They say, Millard, Honorable Supreme Court said that they have to file section 5 limitation petition and other application for setting.
No. If it is delayed, they have to file. This is already pending. It's not delayed.
That is, Millard. And 2 other decisions also. Once they are not brought on record, particularly the appeal abates. Now, before your lordship, the abated appeal is now listed. So, for setting aside that abatement, they have to file 3 applications. 3 judgments.
Well, only technical, sir. In any way has to be allowed.
No, Millard, technical. This was pointed out before this land review court My land friend objected because I have
No,
filed review
objected
petition.
means-
Along with the review petition, I have filed downloaded copy of the Supreme Court judgment. They have claimed for limitation and they got the court imposed 10,000 rupees cost. The certified copy, non-filing certified copy of the Supreme Court.
That
order.
is review. That
Review
is
petition.
gone.
That's why, my lord, I say,
Those cases.
when your lordship know, after the Supreme Court judge orders, that is also communicated to the court. And I have filed that limitation petition. That,
On this substitution application, you have no objection, correct?
that is the only thing, because they have taken
See, it says
10,000
in
rupees.
Miss Case
cost.
187 of 2012, it appears that during the pendency of the review petition number 25 2007 itself, the present on 19th February 2012, leaving behind legal representatives whose details are given in the schedule to this application. Paragraph. Counsel for the respondents objects to the application not on merits, but by pointing out that another application is to be filed for setting aside the abatement in the writ appeal. Full stop. In support of such contention, he relies on an order passed by the Supreme Court in Arjun Singh versus Gurdyan Singh, 2009 to OLR at SC 477.
And last,
Paragraph.
item
It is
3.
seen as far as the above decision is concerned, no application had been filed in that case, and therefore liberty was granted to file such an application along with an application for limitation. As far as the present case is concerned, since an application has already been filed, numbered, is pending, and only not brought to the notice of the court, the court does not consider it necessary to require the petitioner, the appellant herein, the LRs of the appellant herein to again file further applications. Full stop. In the present case, a pending application was simply not brought to the notice of the court. Full stop. Paragraph. In the above, in the circumstances, the application is, for the reason stated in the application, it is allowed, and the appellant is permitted to be substituted by the LRs whose names are set out in the schedule to the application. That's all has to be done.
That's all.
The writ appeal is over already.
No, writ appeal, technically it has to be reheard again.
Why don't we hear it today?
Not today, my lord. It is a big brief. I have to prepare. Let it come after vacation.
It's 2011
also-
matter as it is, it's an old matter, sir.
Old matter, my lord, only now it is
Your
restored.
see that it was comprehensively heard and decided.
No,
with
not
his-
there. I have argued the matter.
Yes, I know.
And also.
Your lordship may fix it to some other
Last
day.
1 week, I am not also well.
All right, counsel, in main
Let it
appeal, you
come
say
to-
counsel for the respondent states that he has not been well for some time and needs time to prepare for the matter. Full stop. At his request, list on.
It will take some time, my lord. Last week of January or first week of February.
16th March. Yeah, let's keep all this.
Weekly list item number 3.
Lord, in terms of the last order, I have obtained instruction and I have submitted the letter of instruction.
No policy allotment of quarters to journalists.
It has directed me to obtain instruction whether there is any specific policy for.
So what is there in this matter now?
My lord,
There's a delay also, right?
under the impugned order,
What's the delay?
your lordship may kindly have a glance over para 3 of the impugned order. That the petitioner has been accredited as state level journalist.
192 days delay. We'll keep the question open.
My lord, the
Only
direction-
one, we'll say it's an isolated case. We treat it on a case by case basis. There's no policy anyway.
But direction has been given to allot him a government quarter, and we have decided by a policy decision that we are not going to. That has to be.
No, there is no policy. You've not taken a policy not to allot. That's why we asked you the question. No policy has been formulated.
Yes.
If no policy has been formulated, then you don't have a policy not to allot.
But Lord, in the similar status, many people will come and say that allot us quarters and etc.
No, there are only one journalist here, no?
Yes.
Only we confine it to his case only. You see, there's no satisfactory explanation for the delay in filing the writ appeal. Consequently, the court is not inclined to condone the delay. Paragraph. Nevertheless, put on both writ appeal and application for delay together. Nevertheless, the court has also examined the matter on merits. Full stop. On the previous date, that is 10th October 2022, Ansett had sought more time to inform the court on whether any policy has been formulated for allotment of government quarters to journalists. Full stop. Mr. Manthi, learned AG, places before the court a communication dated 8 December 2022 of the General Administration and Public Grievances Department, Government of Orissa, informing him that, open quotation, no policy has been formulated yet for allotment by government, then you say SIC, bracket, of government quarters to journalists at Bhubaneswar, unquote. Paragraph. The court, in that view of the matter, since no policy has yet been formulated, the impugned order of the single judge is confined to the facts of the present case. Full stop. In other words, it will not constitute a precedent. Full stop. The writ appeal is disposed of in the application is also dismissed.
Item number 4.
May I please, Your Lordship? This is a matter regarding allotment of a commercial plot in CD area, and initially the opposite party has filed a writ application bearing 23462 by 2011. Your Lordship, kindly see page 2 of the writ application. But in that case, his challenge, he has asked for allotment of a commercial plot. His case was considered, but he did not get. Therefore, he filed that application, and in that case, it is about to be dismissed. And at that stage, the opposite party submitted that if another plot is lying vacant, that may be allotted in his favor. But the relevant portion of that order is quoted at page 2. The Honorable Court passed the order that if he will pay more than the quoted price by the highest bidder, then his case will be considered. So quoted
You yourself filed this review petition before the single judge. There is a review petition tagged with this matter.
Yes,
it's a single judge matter.
I'm review petition. I'm in my review application.
So you filed it before the single judge. So you want to pursue that? You pursue that.
No. Now question is, already allotment has been made. Question is whether he is supposed to pay the interest on the defaulted amount.
Sir, are you pressing this review petition or you not?
Review petition, I'm not pressing. Review petition is done.
No, you will have to tell the single judge that.
Yes. Only now I am challenging the order at annexure 4. Annexure 4 to my appeal.
Why is this tagged like this? What should be there for the single judge? Why is the unnecessarily tagged here? Yes.
Yes. The review.
Not necessary. Say it's a single judge matter. It's not tagged here. It is convenient now for you to say it's not necessary. We have to do something about it. What is your grievance here?
My lawsuit kindly turn to page 2. The earlier writ application filed by the opposite party, in that case, his case was considered and it was able to be rejected. At that stage, he has made a submission that another plot which has been put to auction, it has gone on 58 lakhs and he is ready to pay more than that. Considering that, the order was passed, I am placing it the order. We are therefore of the view that the petitioner having only right of consideration.
Where are you reading, sir?
Page 2. Page 2 of my appeal. Page 2 of my appeal. We are therefore of the view that the petitioner having only right of consideration had been considered for allotment in Sector 11, but the region the said plot could not be allotted in his favor. He was offered an alternative plot, but he did not show any interest to take the said plot. So far as the plot in Sector 10 is concerned, the highest bid so far received by the authority is 58 lakhs. Therefore, if petitioner offers a higher amount than the above, the authority may consider his case for allotment of the said plot in Sector 10 with the above observation. The petition is disposed of. This order was passed on 9/12/2011. After that order was passed, petitioner, the opposite party did not turn up to the office of the CDA and remained silent. 4 months thereafter, he approached the Honorable Supreme Court by filing an SLP. SLP continued for so long time. Thereafter, he withdrew that SLP. After withdrawal of the SLP, he again approached the Development Authority for allotment of that plot by offering 58 lakhs 4,000 only. And was made to him, if you are ready to pay the interest on that, then we will going to consider pay the amount. He has paid the interest, everything he has paid. After making all payments, he has filed a writ application saying that I am not supposed to pay interest on the defaulted payment, so interest may be waived. That writ application was considered and the order was passed because the SLP was pending before the Honorable Supreme Court, so he is not supposed to pay the interest.
Keep the question of law open, sir. It's all an individual case. Why should we interfere?
And the order you also can turn to paragraph.
This is all not to constitute a precedent. This is not going to constitute a precedent, sir.
No,
this writ appeal is never listed in all these years. There is no stay of the
interest is more than 6 lakhs. More than 6 lakhs will be the interest.
Oh, it's all right. You never got a stay of the impugned order.
My lords. No, he has paid the entire amount. He has paid.
Kindly learn to listen, sir, what the judge is saying.
Yes.
The single bench judgment
Yes.
has never been stayed.
No, I am not challenging that. I am not challenging the single judge order in that case where direction was given. I am not challenging that.
No, interest also.
Interest he has paid. After paying the interest, he has paid the interest amount. After paying the interest, allotment has been made in his favor.
Yes.
Have you followed the question? Have you followed the question, sir?
In the
Yes,
second round of
This is one writ appeal, correct?
Yes, yes,
In the writ appeal, you have challenged an order of the single judge, correct?
yes.
Ah,
Yes.
that single judge order, which you have challenged in this writ appeal, has it been stayed?
No, it's not.
Ah, so if it is not stayed, what should happen?
It is
See,
not-
we have to ask you 10 questions for you to answer this
No,
one
it-
question.
The whole thing is it is not required to be stayed because he has paid the entire amount.
One will simply dismiss the appeal. If you're not
Yes.
aggrieved, if you're not aggrieved,
No,
with
I am-
the appeal order, then simply dismiss the appeal.
After that.
Sir, please answer the question.
Yes,
The impugned order
Yes.
has not been stayed.
it is not required to be stayed.
All right,
Sir,
then
this-
you're not
No,
aggrieved by
in
it.
the impugned order,
You're not aggrieved by
after paying the entire amount, the impugned order has been passed.
no. In single bench judgment
Yes.
is not agreed. On the basis of aforesaid conclusion, the CDA is directed to recalculate the interest within 2 weeks from the date of receipt of certified copy of this order and communicate the same to the petitioner who shall comply with the direction of the CDA within 60 days. So that has never been stayed.
Yeah, not been stayed. He's not
No.
aggrieved by it. You're not aggrieved by it, no? You're not
No,
aggrieved by it. When repeatedly asked, just take
No,
this order. When
you'll have to
repeatedly
be-
asked whether the impugned order, which has never been stayed by this court, has been implemented,
I'm
learned counsel for the appellant repeatedly states
Yes,
there is no need to implement the impugned order because the appellant is not aggrieved by it.
No, I am reading.
The appellant is not aggrieved by it.
Let me place the impugned order. News. The operative part of the impugned order is that.
Sir, first answer this question.
Yes.
Are you aggrieved by the impugned order or you're not aggrieved?
If this impugned order is implemented, then I have to refund him the money.
Now you're waking up. Finally, you're not, because you refuse to understand the questions we are asking you. You're just arguing what you want to argue without answering the questions we are putting to you. This is a very strange way of arguing. Very strange way of arguing. We are asking you repeatedly, have you implemented? There is no stay of this impugned order. This impugned order asks you to do something.
Yes, ma'am.
Now, after 10 minutes, you're telling us, as virtue of the impugned order, you have to refund.
Yes, he has not approached. He has also not approached.
You are very
Yes.
happy, sir. He has not approached. You have not done anything. Why should we waste our time? Why should we waste our time? He has not approached you. You have not done anything. And how many years have gone now? 6 years have gone by.
Yeah.
Everybody is happy. He has gone to sleep. You have gone to sleep. Only we are awake. See, the problem is, I'm finding we have unnecessarily created problems for all of you. All of you are in deep slumber. These appeals are never listed. On its own, it is getting listed. When it is listed, you have nothing to say because you have never moved a finger to implement the impugned order. The other man in whose favor it is passed, he has also not moved the court to implement it. Everybody is only, that's what I'm saying, only the court is bothered. Parties are not bothered. Somebody has succeeded, he's not bothered. You have lost, you're not bothered. Why should we be bothered? It's a waste of time. When we ask you these questions, you're saying, why should I implement? You're right. When he has not asked you, why should he implement?
He has not asked.
Because he has not asked, you're under no compulsion to implement.
He has paid the entire money, but thereafter
he has not asked for refund. You're very happy, sir.
On 10/8/2016, they have received the application from the respondent to refund that money in view of the.
So you have told your client, sir, please go to sleep. I will also sleep. You also sleep. Let us not worry about these things. Don't get back your money. Although you have succeeded, you have told your client, please go to sleep.
And he has approached the CDA authority for.
No. After which your advice is perhaps to him, please go to sleep.
10/8/2016, immediately after.
Not necessary.
1 month after.
Actually, you are wasting time. It's a complete waste of time of court, sir. No party is interested in anything. Why should we bother our... You see, all that the impugned order does is to require the appellant to recalculate the interest amount, and if any refund is due to the respondent, to refund the amount to him. Full stop. Counsel, the appellant, when repeatedly asked why the impugned order has not been implemented, simply states that the respondent has not approached the appellant for its implementation. Full stop. No point is able to be made by the appellant before the court as to why the court should interfere with that order at all. Full stop. On his part, counsel, the respondent states that the appellant has been approached way back in 2016 itself.
10/8/2016.
On 10/8/2016. Stop. However, after that date, the respondent doesn't seem to have pursued the matter. Paragraph, in the circumstances, the court sees no reason why it should interfere. The writ appeal is dismissed. In the review petition, you say counsel for the appellant makes a statement here that the appellant is not interested in pursuing the review petition. Stop. The review petition will be treated as having been withdrawn and dismissed as such.
Item number 5.
Item 5 permitted to be withdrawn, madam. Matter is in praxis.
All right. Dismiss is withdrawn. All right.
Item number 6.
Sir, item number 6. Sir, I'm the appellant and appearing before you another second time.
All right.
Due to this complication of my counsel, been shifted to New Delhi for post-operative complications further.
So what do you want, sir?
So I want 2 weeks time.
All right.
Either
The
he has-
appellant who appears in person states that his counsel is unwell and seeks an adjournment. At his request, list on second March.
Weekly list item number 7.
None appears dismissed.
Item number 8.
May I please, Your Lordship?
Yes.
My lord, in this case, we have challenged the notice, the demand notice issued by the opposite partner for regarding ground rent, cess and incidental charge for land allotted towards
This is only some restoration application, sir.
Lordship.
What is this restoration for?
The matter was dismissed for default, Your Lordship.
But nothing's happened. Obviously, it's not heard.
Lordship, in the meantime, the coal block, the land was allotted for coal block. And now the coal block has been cancelled, as well as due to the CIP proceeding, This,
Then let's just dismiss it. The CRP proceeding will take care of everything. You said-
Lordship, I have given a similar order, my lord, Your Lordship. Your Lordship can, in the case of the petitioner only,
No, that is in a pending writ petition, sir.
Lordship.
This is only a CMAPL. The court is not persuaded to, having examined the petition, the court is not persuaded to recall its earlier order. The application is dismissed. Right.
Number 9.
May kindly be passed over.
All right. Pass.
Item number 10. Item number 10.
None appears dismissed.
Item number 11.
No instructions.
Item number 12. Item 12.
Item 12. That my lord, our last occasion was directed to give a affidavit. Sorry, my lord, we have prepared affidavit, but the prescription what need according to the order, my lord, it's required to give prescription. They have given a death chart and a chart wise how many patients have treated. 15 first, then 1%. 16 patients they have already been treated, my lord.
No, one is dead now.
One is absent, yes.
No,
One is 16 is
he has
absent.
died.
The Assis Pradhan is absent. If lordship required, I will
Not-
give the affidavit
not-
just now.
not-
I can give day after tomorrow will all the documents.
Not absent, but he has breathed his last one.
With your lordship, another matter 35002. It is similar to this application. Taken up along with that tomorrow. Day after tomorrow.
All right, at the request of Mr. Padi, list on 21st, along with writ petition civil
35002 of 22.
35002 of 2022. Mr. Padi states that he will positively file the affidavit
Within
in
2
terms
days,
of
man.
the
Within
earlier
2
order
days.
by that date. My lord is fixing to which
21st.
21st, my lord. I have some personal difficulty. Can it be Friday? Friday is not difficult. We are in personal difficulties. Thursday, my lord. I have some Thursday. Oblige.
Item number 13.
My lord, small pardon, my lord, item 10, it has become infructuous, my lord.
Or 10 is dismissed as infructuous.
Infructuous, my lord.
Item 13.
May I please, Your Lordship? This PIL filed by the petitioner, Lordship, the grievance of the petition is that for the regularization of the government land in the name of the school, Lordship. As per the notification under Annex 3, Your Lordship. Under Annex 3, page 67, the OP2 has circulated notification of Lordship to all collectors. Regularization of land in favor of the government and government-aided educational institutions under school and mass education department, Your Lordship. In view of that, Your Lordship, the petitioners and the villagers filed their representations, which have been pending before the opposite party authorities, and that has not been yet considered. And in Annexure 5, Your Lordship, there is a report was called for in the there was a Janaswani before the collector, Your Lordship, and accordingly, page 58, Annexure 5, Your Lordship, there is a report by the sub-collector, Your Lordship, from the Tahsildar Gondia. Given that the Sabik status of the land is though jungle, there is a requirement for necessary permission from the forest authority.
You should move the regular statute for all this, not PIL.
My lord,
You don't have record title of land and some ROR, not like this is not the route for that.
as per
You have to look at the statutes, you have to see how to invoke the statutory process. Everything can't be PIL and representation. Sorry.
The only
Everything is shortcut, sir. For every problem under the sun, representation followed by PIL. Then you get a direction saying dispose of representation, then file contempt, then file second petition, keep filing contempt.
No, my lordship.
No need to invoke any statute, nothing.
The grievance, Your Lordship,
You can have grievance about so many things under the sun, sir. For some grievance, the statute. But that statute, there's a procedure.
My lordship.
So you have to invoke that procedure.
But here, Your Lordship, the petitioners, the villagers, they have approached to the authorities, Your Lordship, and they have not done anything.
Approaching, sir, there is a statute for these things. If you want record of rights to be recorded in the name of X, there is a statute, there is a procedure.
No, my lordship. Your Lordship, kindly have a glance on page 67, Annex 3, Your Lordship. That is the circular, circular on 30th 10/2021, Your Lordship. The authority who directed all the collectors of the state to regularization of land in favor of the government and government-aided educational institution under the school and mass department, Your Lordship. And there is also a time limit to execute the same, Your Lordship. That has not been executed so far. Our school is concerned, Your Lordship. The school is functioning over the land since 1972, Your Lordship. And the villagers and the school authorities, they have moving the authorities since, Your Lordship, 86. And there was also an inquiry, Your Lordship. But till yet, that has not been concluded. So I pray, Your Lordship, the authorities may direct it to 5 is the collector, Your Lordship, as in compliance to the Annex 3. The OP5 may be directed to consider the representation on Annex 6, Your Lordship. I specified everything in the Annex 6 and the laws given. If a lordship,
it is not a case where your lordship may kindly have a glance.
Something else going on here.
If a lordship,
Annexure 5, page 85.
If a lordship examine Annexure 5, Your Lordship, on the plea that the Sabik land, the present status of land is Anavadi. The school is running over. There is in the ROR I have annexed Annexure 1 series, Your Lordship. The image column, the school is situated. That is there, Your Lordship. But in the Annexure 5 at page 85, Your Lordship, kindly have a glance. On the plea that the Sabak record of the land is Gramya Jungle, so it is required permission. But Your Lordship, under Annexure 1 series, Your Lordship, the inside the school premises, Your Lordship, the private persons have been allotted land by the government on the plea of lease and OPL, Your Lordship. But they are allotting the school compound to the private persons. We're dealing to record it in the school name, Your Lordship. If they will continue such delay, Your Lordship, subsequently the school premises will be handed over to all the private persons, Your Lordship. That the annex, the RORs I have annexed, Your Lordship.
Who are the private persons?
The ROR, Your Lordship, I have annexed under annex.
1 minute. Who have you made them parties?
No, my Lordship, I have no grievance against them, Your Lordship. I have a grievance against the authorities, Your Lordship.
You are saying inside the school they're allotting land to private persons and you have no grievance.
Yes, Your Lordship.
They have allotted it to private persons school land and you have no grievance.
Yes, my Lord.
What are you saying, sir?
No, my Lord.
I think you're contradicting yourself.
No, my Lord.
You just now said land within the school is being allotted to private persons, and if it goes on, according to you, if this goes on, the entire land will go to private persons.
Yes, Your Lordship.
And then when I ask you have a grievance, you say you have no grievance.
No, I have grievance, but I have not made them individual.
Because you don't want to make them parties. Yes. When I ask you to make them parties, you will say I have no grievance. Suddenly grievance will vanish if I ask you to make them parties.
No, my lordship.
Yes, that's what it means.
If a lordship.
Sir, this is all half-baked. This is what is called half-baked.
No, my lordship.
Just put them the representation of all problems under the sun, put representation without naming a private parties, impleading them. Then they will come rushing to the court the minute they do something on your representation.
No, my lordship. Your lordship.
It's all half-baked, sir.
Sorry, my lords. The sole grievance of the petition is to record the land in the name of
If it was so simple, sir, why are you coming to the court? If it was so simple,
no,
obviously it is complicated, correct? You have yourself, it is complicated.
That is complicated.
So complicated things, hide away the complications, present it as a simple problem for a simple solution. This is a very nice way of doing things, but not the correct way of doing things.
My lord, if my learned friend will allow me, I will only place before your lordship annexure 5. That will suffice everything. Last 5 lines of annexure 5, page 85. His grievance has been taken care of, and the Tahsildar, what the Tahsil did in response to this office request, the OIC Record Room Dhenkanal Settlement Office has reported that Sagbik Kisam of land of the applied plot belong to Jungle Kisam. As necessary permission for diversion of forest land for school purpose is required, the BDO Gondia has been requested by this office letter the forest diversion clearance from the Divisional Forest Officer Dhenkanal for further processing the alienation case. Further course of action will be taken after receipt of the same. This is the letter dated 29th August. So the matter is in the process. He is only premature. They are coming to court.
There's obviously something more. He says there are some private persons.
That is a different. That is not the subject matter of this PIL.
Anyway, that seems to be his apprehension. The real apprehension is that all this land will go to private persons.
No. That is taken care of. This letter itself reveals that we have to get the forest clearance. That is all.
What do you wish to do, sir?
That representation disposal of order will not be.
No. Action is issued to the collector to expedite action pursuant to Annexure 5.
Yes, ma'am.
Which is a letter dated 29th August 2022 of the Tehsil Office Gondia to the Sub-Collector Dhenkanal. Since the grievance is limited, a direction is issued to the Sub-Collector Dhenkanal.
In place of collector, it may be a Sub-Collector.
Sub-Collector Dhenkanal to act on the said letter and takes appropriate steps as expeditiously as possible.
In a certain time,
that is that diversion case. It will take some time because diversion proposal we will do it. Otherwise, this letter will not
record.
Preferably within a period of 12 weeks. All right, the petition is disposed of.
We will list item number 14.
The issue is already settled in by Supreme Court in Reliance Industries.
All right.
The recent order passed by your lordship.
In the same order.
Item 15.
15 is also the same.
15, item 15 only, I pray, if cause of action survives.
No, we're not
back interest. There are 3 aspects. One, interest and demand is already paid. From 2017 onwards, up till date, interest has been paid. So far as admitted 2/3 tax is concerned, that is also has been paid. But prior to 2017, the period so far as interest is concerned, that is sub judice before your lordship. So I pray for if any fresh demand is raised with regard to that particular period, I may be given an liberty.
That issue is not here, your lordship. Your lordship may kindly turn to the prayer. All the prayers
will you please keep quiet?
Judgment, your lordship.
Will you please keep quiet?
Mr. Rathar, we will not tolerate this kind of a submission here. Please retract that statement and apologize to counsel.
My lord,
Mr. Rathar, please apologize to the counsel.
I apologize, my lord.
Yes. Yes, what were you saying?
Your lordship, at page 30, your lordship may kindly turn to the prayers at page 30. All these prayers are, your lordship, so far as the issue that Reliance Industries case, which has been overruled by the Honorable Supreme Court, your lordship.
Yes.
And your lordship, for that reason, due to that judgment dated to 28 March 2017 in case of State of Odisha versus Reliance Industries,
Right.
this case became infructuous, your lordship.
Right. No, what he's saying is if there's any other grievance, he may seek other
Your
appropriate
lordship,
remedies.
we have not done so far as that.
He says if you do it, he will seek appropriate remedies. That's
Your
what-
lordship, your lordship.
All right. That none of the prayers survive in view of the judgment of the Supreme Court and Reliance Industries. If there's any other grievance that if there's any further cause of action that arises, it will be open to the petitioner to seek appropriate remedies. The petition is dismissed.
Great.
All right.
Item number 16.
May I please, your lordships?
Yes.
The petitioner has undertaken a work, your lordship, in view of the agreement under Annexure 1.
Yes.
Page 11. Annexure 2, your lordship, I'm sorry. And the work is made improvement of to right flood Kokolova from village Gayagonda to Borodongo.
Yeah.
But it is a composite work, your lordships. I will take to your lordships to Annexure 3, page 29. The description of the work is given, my lord. Your lordship may come to my lord, clause M.
Sir, all this is like a money claim, sir. You can't just file a writ petition for this.
No, my lord, it is only return. The GST has not been paid to me. It is not the money claim.
You can't file a writ petition for GST
Your
return.
lordship, similar matters has been disposed of by your lordships.
The same representation. This
Yes,
is
it
an
is.
easy route, sir. I'm telling people here.
By discussing that,
See what happens for every problem under the sun. Don't go to the statute. Don't invoke statutory processes. File representation.
Only, my lord.
In Orissa, the easiest problem for lawyers, no problem. Any client walks in with a problem, you say, sir, let's draft representation. First, draft representation, send it to whichever department. Of course, the department will not do anything because they're flooded with lakhs of representations.
Only
Next, file a
implementation of
petition.
Annexure 4, your
Tell the judge, sir, very easy, sir. Just pass order to dispose of representation. We are very happy.
In
Passing
view of
such orders.
Annexure 4, your lordship was pleased to direct
No limitation, no law, nothing. Just dispose of representation. Then next is contempt.
Your lordship may kindly see Annexure 4. In view of that, my lord,
This culture has to
notification of
stop.
the
Sir.
government.
Otherwise, lawyers, what is happening is lawyers are not bothered to read the statute anymore. Not bother about limitation, nothing. Every problem, even if it's a 20-year-old claim, file representation. Straight. This itself is a little old, no? Period return pertains to which period? This GST.
GST, your lordship, is 2017.
Where are we now? So today is what year?
No, completion of the work is your lordships. Completion of the
So writ petition, we have to decide all this. So if you filed a suit,
completion is 2018.
correct. So if you filed a suit,
Final bill is your lordship may kindly see final bill.
no. So
Page
sir,
38.
Mr. Mahapatra,
My lord.
Mr. Mahapatra, when you see all that, will you not, if you file a suit, will this all not become relevant, sir? If you filed a suit for this money claim, will this not
3
become
years.
relevant?
Limitation is 3 years.
So here it's shortcut, no need. In 2 minutes, we'll pass an order saying dispose of representation.
Your lordship may kindly see the final bill, page 38.
See, what are we doing to law? Just see this. We don't advise current client correctly. We say, sir, any problem you have, no problem, sir. Let's first draft representation.
In fact, remain that though your lordship has interfered in the matter, therefore I it is restrained.
We will, sir. See, we are very happy disposal. You are very happy disposal.
Similar matters.
Mishra is very happy disposal. Everybody is happy. Client also is very happy. You'll say, sir, we have actually succeeded before the High Court. See, disposal of representation.
Absolutely. But though, my lord, earlier,
What's happening is this, sir. This is all shortcut culture. It's not solving any problem. We're only multiplying our problems.
Though, my lord, your lordship has interfered in the matter.
No interfering. In fact, this is a non-interfering order when we say dispose of representation. We're also passing those orders.
My grievance is only, my lord, to implementation of Annexure 4.
Yes.
That's the, though, my lord, Annexure 4 and in view of that Annexure 4, your lordship was pleased to decide 2-3 matters.
Not passing that order, sir. We're not passing the order.
Your lordship may keep it to some other.
No. This is a petition seeking refund of a GST claim. Pertains to some transactions which took place in 2017-18.
Your lordship may be pleased enough only
for which the statute
to consider.
And there's a whole procedure for claiming refunds under a statute. Court therefore does not propose to entertain the shortcut of a representation and disposal of a representation. It will be open to the petitioner to seek any other appropriate remedy that the petitioner may have in accordance with law, the petition is disposed of.
Item
Lordship,
17.
direct the state council to take instruction over the matter, the what step they have
Same,
taken.
sir. 17 is the same thing?
Same.
Same order. All right.
Item number 18.
May I pray, my lord, before? Lordship, may direct the state council to take instruction. But why, my lord, the GST has not been paid to?
All right.
Item 18.
My lord, I am for the petitioner, my lord. My lord, in this case, my prayer is that I am seeking a direction from this honorable court for disposal of my appeal, which has been preferred under Annex 6, my lord. My lord, I am in that case. I am challenging Annexure 8, my lord. Lordship, may kindly have a glance.
No pre-deposit. You do not like pre-deposit.
My lord.
You do not like pre-deposit, sir.
Millard, yes, Millard. Because Millard, your Lordship may kindly have a glance on Annexure 8 series, page 51.
Right.
Lordship may kindly have a glance. Very peculiar thing. The outstanding demand amount is 234,950. Accrued interest is 12,640. Again, page, your Lordship kindly have a glance on page 52, Annex 8. Then it was subsequently converted to 2,27,94,780 and 1,13,735. Millard, both the demand out right side, your Lordship may kindly have a glance. The authority has mentioned demand outstanding is correct and collectible. And second, first is also mentioned. Then which one is correct? This demand outstanding is correct and collectible. And challenging this, the petitioner has preferred appeal under Annexure 6, Millard. And I am seeking a direction from this honorable court for disposal of appeal, Millard. And now they are in pursuance of such demand. They are trying to take coercive action against me and already freeze my bank accounts, Millard.
You're reading your prayer in your writ petition incompletely, sir. You want to read it properly?
Millard?
Do you want to read your prayer properly or incompletely?
Read properly, Millard.
Please read it properly, sir.
In view of the above circumstance, this honorable court graciously pleased to admit this writ petition, issue notice on opposite parties, and after hearing the parties issue a writ in nature of mandamus or any other opposite party appropriate writ to quash the demand notice under Annexure 8 series and direct first appellate authority to dispose of the appeal preferred by the petitioner under annexures within a stipulated period of time. So given by this honorable court without demanding any advance deposit.
Now you're reading it properly, sir. Now you're reading it completely. So what is your main prayer, sir? You want to summarize your main prayer?
Main prayer is that, Millard,
that they should dispose of your appeal without asking for pre-deposit, correct?
Yes, yes.
If you had simply answered your first prayer, you would not be happy. We have no problem, sir, asking them to dispose of your appeal strictly in accordance with law. All right. We'll be happy with that, sir.
Willard, Annexure 80, I have already shown those two documents, Willard.
No. So we'll ask them to dispose of your appeal strictly in accordance with law.
Your Lordship so desires, Willard.
All right. Counsel for the petitioner is happy if this court gives a direction that the appeal filed by him should be disposed of strictly in accordance with law. It is so ordered. The writ petition is disposed of with a direction that the appellate authority should dispose of the appeal only strictly in accordance with law. Next matters. Next matter.
19.
Yes. All right. Sir, this is what you wanted. We have given you that. All right.
Item number 19.
Yes. Yes. Yes.
My lord, in this case, the petitioner has filed this application, my lord.
Yes.
Challenging the action of the opposite party number 2 collector.
Yes.
By allowing the shifting of a IMF sub from Joda Bodbil municipality to the Joda municipality in the middle of the excise year, even if the notice for invitation objection was invited to shift the said shop to ward number 6 of the Joda municipality, but the shop has been allowed to operate at ward number 8, my lord, in gross violation of the statutory provisions, my lord. When the specific exclusive privilege has been granted a particular area.
1 minute, there must have been a public notice. Did you file an objection?
My lord, I have filed objection.
When did you file it?
Annexed, my lord, 5/12/2012, my lord.
That is
22.
beyond the period.
Yeah, obviously. What is the bus?
My lord, they have under annexed notification has been made for inviting objection from the ward number 6, my lord, for shifting of the same. Now they have going to shift at ward number 8, my lord. Now accordingly they have shifted in ward number 8 on 8/12, my lord.
Was there a public notice for the shifting or not?
My lord.
Question number 1.
My lord.
Was there a public notice?
Public notice was invited on
Annexed
3. Annexed 3, my lord.
What was that?
That was the word that has been mentioned at page 30, my lord.
The last date was
What was the last date for that public notice?
3rd October.
3rd of 15 days. Inviting objection from the local people of ward number 6, my lord, of the Joda municipality regarding the.
No. If the shop is shifting to ward number 8, was there a public notice for shifting to ward number 8?
No, my lord.
No.
Notice of objection was initially the shop was situated at ward number 8 of the Bodbil municipality, and the shifting was made to be at ward number 6 of the Joda municipality. Objection was invited accordingly to shift the 6 of the Joda municipality, my lord, ward number 6. So that subsequently they have now allowed to shift the set to ward number 8 of the Joda municipality, my lord.
My lord, he is saying that shifting order has already been passed.
No,
that is not annexed. Where is the shifting order?
They have allowed to operate on 18 to 12.
So that allowing to operate must have been followed by an order of shifting by the appropriate authority.
Order
Where
of
is
the
that
shifting.
order?
This is the order of shifting notification.
Which one? Annexure?
Annexure 3 is the inviting objection.
That's the public notice, Annexure 3. Where is the order for shifting?
Order is not available. That is
Order is not available. This is in public domain. You are saying it. May kindly see the prayer. What is the prayer?
Only
see the
let
prayer.
me clarify Annexure 3, my lord. Objection was invited for shifting of the same to ward number 6 of Joda municipality. Even if that now they have shifted to another ward of the Joda municipality, my lord. Rather, my lord.
Actual position is not clear at all.
Not at all clear. Just I am placing the prayer. Just a minute. Be pleased to quash the order of the collector in allowing the OP number 5 to operate the IMFL workshop Joda made pursuant to its notice dated. So, where is the order of the collector?
Allowed the operator at
that is not there in the writ petition. It is not annexed.
I have abhorred in my writ petition that
immediately that you have to impugn it in your writ petition.
But specifically about that,
he should file a better application by annexing the order by which the collector has purportedly allowed the shifting. That can be challenged.
Well, I have specifically mentioned in my writ application.
Maybe, but that has to be
objection was invited to shift the same to ward number 6 of the Joda municipality.
Objection was invited in October. Thereafter, according to him, it is already done. So that has to be challenged.
That has been challenged in this area.
Where is that? Which is the annexure?
Let me submit my case.
Where is the annexure?
I have specifically abhorred in my writ application.
That's not good enough, sir.
Although there has been specific objection was invited for shifting of same 6th of the Joda municipality, the authority with a malafide intention hurriedly, even if in violation of the notice, my lord, in violation of the no objection invitation notice, they have allowed to.
What is that allowed, sir? Allowed orally? Allowed orally?
I have on 8th. Now he is operating.
Allowed orally or in writing?
Now he is operating on 8th, my lord.
1 minute, sir. Just answer this question. Allowed orally or allowed in writing?
Now the authority must have been.
Must have been? What?
Allowed pursuant to this objection.
Allowed, sir, again, third time I'm asking you. Allowed orally or writing?
Orally cannot be
Writing order is
allowed.
not
There has to be a shifting order,
shifting order
which
is
he
not
can
available.
get from public domain or under RTI Act. If he
Shifting order
shows,
is not available with us.
no, you have to get it.
Since the no
File
objection,
in the RTI, or all of you are very resourceful, sir. File in RTI, get a copy.
Then challenge it.
Since our grievance is that since we are the license holder of the ward number 18 and operating the license, taking into consideration the privilege area and which has been fixed, the MGQ has been fixed, taking into the consumption of the locality. Now in the meantime, operation of the
Competition. Now the fact is coming out. Coming out.
Petition of the license holder. I have a specifically about me. Petitioner is the license holder of the ward number 8 my lord of Joda.
You have to, then you are very resourceful, sir. You will get a copy of the order, then challenge that order. All right. The petition, the petitioner's frame is incomplete.
My lord, petitioner
petitioner is aggrieved by an order, purportedly by an order passed by the collector regarding shifting of an IMFL offshore.
To ward number 8
however, he has not enclosed a copy order. Full stop. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a better petition.
This writ application may liable.
Disposed of as withdrawn with liberty. All right.
Item number 20.
Okay.
I have filed this petition.
The recall of an order and a review and all is very innovative, sir.
Pardon?
As it is, it's a revision.
No,
order has been passed as review petition. Now IA for recall of that order.
No, not this order. My lord, that is dismissed. I was absent because I could not know the list.
Review petition means over.
But the review petition.
Now you know, sir, where to go.
Yes.
Review petition over is over.
My lord.
Review petition over means over.
No, that unless that is order review is restored.
Nothing
Yes,
turns
there is a case, my lord. What happened if my lord will permit me on merit?
All right. You make an attempt.
My lord.
All right.
This order of the Honorable Division Bench, which is sought to be reviewed in this review petition, is at Annexure 4, page 45. This arises out of my lord, disposal of the original application 1758 of 2018.
What prevented you, sir, 1st November?
No, madam. I missed the list. That's my personal difficulty. I was not there in the. I missed the list.
You are not a person who misses the list, sir.
No, but I very often because my name sometimes comes in Samir Das and sometimes that is the difficulty I am facing, my lord.
Anyway, what is that?
So, my lord, kindly see this order. In the original application, in the tribunal, in way number 1758 of 2014, we are the parties. But what happened? The background of this case is government has taken a decision in 2014 to regularize the SC/ST in 2 to 3 lines. I will not take much.
Suppose we restore this review petition, dismiss it, saying no grounds for review. Same result.
No, my lord, it will. I think my lord will consider if I will submit.
All right.
My lord, just there was a government order in 2013 directing regularization of the Gana Sikyak.
Right.
Scheduled caste Gana Sikyak. We are the scheduled caste Gana Sikyak of Ganjam district.
Right.
We are 69 in number. So by virtue of that order, we have been regularized by the collector Ganjam. We have been continuing. In the meantime, some UR category candidate, they challenge that our government resolution in our support of the scheduled caste in the tribunal in 1758 of 2014. In that case, we are parties. We have filed an intervention petition that was allowed and we are parties. That order I have given, my lord, because this is a voluminous order. Kindly see, we all this petitioner from 20 serial number of the opposite party number 25 onwards. In that way, we are parties. But some of the opposite part, some of the persons, by agreed by that tribunal's order, they come to this honorable court in the present writ petition, didn't make us parties. And virtually in the writ petition was allowed, which goes against us. Our service is to face the recognition. That is why I filed a review. And on consideration of my review petition, the same honorable bench of this honorable court has granted an interim order directing notice. And opposite parties have also appeared in this case. I have served a copy. My learned friend is there. They have also appeared. And they have admitted that fact that yes, we have not been made parties in the writ petition. though we are in the party in the tribunal. And the tribunal didn't pass any order in their favor, the UR category. So now our regulation by virtue of this order, that is true. That is the concern in this case. Had we been given that is why my lord have directed in the review petition that yes, will be given opportunity, and that review was pending and it was listed, and to my misfortune, I could miss the list and this. The only thing, my lord, today also I am ready in the review petition.
Nothing to argue with the application, they're arguing the review.
Review, my lord. Yes, ma'am.
No, you're right. It's arguing the review only. There's nothing to argue with the application.
My lord. Kindly have that order I have given to my lord. Today, that was the better application I filed order in way number 1558 of 2014. Kindly have a glance to the cause title of that case. Cause title. Some serial number 25, 26, 27, 28, 30, 32. All these persons, except a few, we are the opposite parties in the case, and we are the beneficiary of the order under Annexure 2. This kindly have a glance to page 25 of the review petition Annexure 1. This is a government resolution 4/12/2013, wherein a decision was to regularize the scheduled caste type Gana Shikshaks continuing in different districts. That will be, my lord, will be clause 7 of that list at page 27. By virtue of this government regulation, now, my lord, this order was implemented in respect of the present review petitioner at page 31, Annexure 2. We all have been regularized by the Jilla Parishad Ganjam Chhatrapur as regular primary school, Jilla Parishad teacher.
Yes.
My lord.
Yes.
This Annexure 2, page 31.
Right.
These are the regulation order of the petitioners, present petition before my lord.
Right.
And being agreed by this Annexure 1 government resolution, because it was some order in our favor of this scheduled caste tribe, they have the UR category candidates come to the tribunal in that 177858 of 2014. And we were made parties or intervention allowed. We have contested the matter, and finally the tribunal didn't interfere with that resolution of the government. So we have to continue. However, an observation was made, if the government can do something for the UR category, then let them take a decision. Because this is a special reservation given to the, by relaxation the rule for the scheduled caste. That was the order.
So delay was condoned, sir, in the review petition?
Pardon, my lord?
Delay in review petition was condoned.
Review petition delay. because we are not parties, probably that is, I have not verified, but my not can verify. But 200 model was passed in that.
It is shown that 215 days delay was there in filing the review petition itself. So whether that was ever condoned.
That part I have not, sorry, my lord, because the tribunal, the honorable court has issued notice in that case, and the opposite parties appeared, and interim order was passed. So it is my fault, actually, I have not verified, but I think it is because parties, so that petition was there, that's why we have committed delay. So that is why the court has accepted. If that is not condoned, my lord,
so
I will place that
this case
petition.
number 84 of 2017 was never taken up.
Pardon, my lord?
No, notice issued.
Notice was issued in
Notice
that.
was issued.
Interim order was passed subsequently. It was listed.
What is the date of the interim order, sir?
Interim order?
My lord, there is 2/11/2017 as per my.
Yes. Because there are some other cases, the court has directed all the proceeding will state and it will be heard.
But there is no order regarding condonation of delay.
Yes, that.
Yes, sir.
Well, that may be because I could not. But the condonation of delay, my lord, my ground was that because we are not made parties, but originally we are parties, so it is not within our knowledge that may be condoned. That was the petition before, my lord. My lord, we consider that. Now, my lord, on this order, writ petition, original application that I have stated, 1758 of 2014, we are made parties, but some of the every person they challenge it in WPC 11218 of 2015. That order is at page 45, impugn order, annexure 4, page 45. Kindly have a glance, my lord. We are not parties in the writ petition. Though actually, in effect, my lord, we the person are the person aggrieved. Because we have to face difficulty now. We are not made parties. But the writ court disposed of the case without taking note of that fact. As I have verified from that record, the entire, I have given the certificate copy Xerox, my lord. They have given a this after amendment consolidated petition they have not given. So the entire cause title was not before the honorable court. That is why probably the difficulty was. So when I have immediately after this judgment, when we faced termination, so we came to this honorable, to this honorable court with a review. And the review petition, my lord, the facts is before my lord. Only so far because if this will not be accepted, my lord, with this scheduled caste person of 69% for no fault, will be out of employment. Will be reverted back to the post of Sikhana Sikhyat. And the government consistent case is, after the judgment of the tribunal, one aspect they have also submitted before this honorable court. The tribunal has directed for consideration of the matter by the of the UR category, but the government in annexure and have a glance. Government, while considering their case, also rejected their representation. So, suppressing that their representation, rejection of their claim, they filed the writ petition against the original order of the tribunal. But normally, my lord, if my representation is rejected, I have to go to the original court. And the tribunal was alive at that point of time. So what they have done, they filed a writ petition against the original order. And we are not made party. And a judgment of this honorable court division bench, they are also, my lord, one of the honorable single judge, without noticing the order, opposite parties who are parties, disposed of the case, and this honorable court, I have given a judgment. I remitted the matter for rehearing of the writ petition.
Whom are you appearing for, sir?
I am appearing for the opposite party.
You want to come to that mic, sir?
Yes, ma'am.
They are the writ petitioners.
My lord, we are the writ petitioners and we have made bet number 5 to 15 in this review petition. My lord, OA numbers 175 after 2014 was and batch were filed before the tribunal challenging the resolution of the comment dated 4/12/2013. In that way, we are not parties. So we intervened in that matter.
and thereafter the review petitioners also intervened. But in the judgment, OA judgment, their name was not there. That's why.
But they were present.
Yes.
But they were present.
But they intervened.
Oh, I see. They were heard.
Yes, my lord. They were had subsequent to our intervention, they intervened. But in the court title, but voluminous judgment, a number of cases were disposed of by one judgment. So name was not there. Since we intervened, so we filed a writ application challenging that order of the tribunal. In that,
No, he says in the writ application they were not heard. Is that correct?
Yes, my lord, they were not made parties. But that was a bona fide mistake on our part because their names were not.
Bona fide mistake?
Yes, my lord, because in the tribunal judgment their names were not there.
Don't use adjectives. It's a mistake. You can say. Don't say it is bona fide.
But because of that, because their names were not there in the tribunal judgment in the cause title. So, the writ petition, they were not made parties.
So, can we send it now? Have the writ petition heard again? Let them be heard.
Well.
Do you yourself admit you made a mistake?
Yes.
Yes, my lord.
All right. The original writ petition, you say for the reason stated, the application is allowed. Review petition number 103 of 2017 is restored to file. Review petition, you say counsel appearing for the original writ petitioners admits before the court that the review petitioners ought to have been heard in the main writ petition and that they were left out by mistake. Full stop. He admits that the review petitioners were in fact interveners before the tribunal, whose orders tribunal and the order of the tribunal when the order of the tribunal was challenged by the present writ petitioners. If by mistake of impleading the present review petitioners as opposite parties. Paragraph. In view of the above statement, the court reviews its order dated 1/9/2016 and restores writ petition civil 11218 of 2015 to file. Full stop. In the main writ petition 11218 of 2015, he was before the roster bench on 6th February 2023. All right. All the time.
Item 21. Item number 21.
None appears dismissed.
Item 22.
My lord, this application has been, my application has been dismissed for default.
When was it dismissed?
When I was not expecting the matter to be taken up, and I was personally not very well. I left the court with the instructions to my associate, but I think proper steps were not taken. If this draws your lordship's sympathy, then it may be restored. This is basically, I am a candidate for the judicial service, and I have secured marks to be qualified for interview, and I was waiting for that.
Dismissal of order. Delay.
7931.
Right.
No, 590 days. CM appeal delayed by 590 days, sir.
Well,
21. There is no delay. Where is the order dismissing for non-prosecution? Where is the order? It's not scanned. What has happened in the last 6 years, 5.5 years? This writ petition was dismissed for non-prosecution on 27 June 2017. What has happened in the last 5.5 years? I think my copy is not there. This is 7931 only. I don't know. No, 731. Number 7. Wrong file since 7 before we. But his file is correct. His file is correct. It's all right. What has happened, sir? What does that mean? Eloquent. It's very eloquent, sir.
Eloquence doesn't matter before your lordships. Your lordships only take into consideration the essence of the matter.
How old is he now? Time flies. No, time doesn't wait for anyone, sir, unfortunately.
My lord, this came on my way when I was trying to examine the matters which are pending. And that's why in fact, I will concede that I do not remember, my lord, that who is this person who had handed over this deed to me. But at the same time, when my associates pointed out that if he is such a meritorious person, and if you would have pursued the matter, maybe it's my folly. Therefore, my lord, because of my folly, let this boy not suffer.
Yeah. But the petitioner was already 35 years. When it was filed in 2016, was for a direction to the opposite parties to re-evaluate his English paper in the Odisha Judicial Service Exam 2015. It is that petition which was dismissed for non-prosecution by this court on, which was the date? 29? 2017. 27 June 2017. The recall of which is sought in the present application. Paragraph. The purpose of restoring such a writ petition would be pointless, since the relief cannot be granted to the petitioner in view of his being overaged for being considered any longer for the OJS. Consequently, the court is not inclined to entertain the present application. It is dismissed.
Item number 23.
May it please your lordship?
Yes.
It is a 4 days delay in filing the appeal.
Tell us what it is about, sir.
It is another thing, annexure 2 and 3 may be dispensed with filing certified copies, my lord.
All right.
And this is against the state order of waiving under Rule 26.
So now the appeal is pending or still not over?
Over, my lord. In view of the discussion analysis, the appeal filed by the main appellant is partly allowed, except the confirmation of duty of demand of 3,93,805.
So the penalty of 3,93,000 monetary limit must be much more, sir. The monetary limit for appeal must be much more.
My lord. 17.
For central excess matters, what is the monetary limit in the High Court?
The 15 lakhs.
15 lakhs. So the monetary limit is far below the. No, you see, the tax effect in the present case is far below the monetary limit. Consequently, the appeal is not entertained. It's post off. The delay is controlled.
And my appearance may kindly be noted is a transferred brief.
100%, sir. You can be fully assured from us.
I'm sorry.
Item 24.
Yes.
May I please? The department has come up before Lordship, my lord.
Yes.
Here certain fabrication items and supporting structures and that was show cause notice was issued. The commissioner decided against the SSC. The SSC went up in appeal before the tribunal. The tribunal has reversed the finding, my lord. Our only ground, Lordship, may kindly see the page, my lord, 11 is the order of the learned tribunal. With the 2-page order, my lord, none of our submissions have been recorded. Basing upon one judgment of the same tribunal, the matter has been disposed of, my lord. Lordship, may kindly see internal page 2 of the appellate court's judgment, my lord. That has been paid, my lord. Lordship, may record my submission. Today has been paid.
When was it paid, sir?
Today, my lord. Lordship, may kindly see internal page 2, my lord. Judgment of the identical case passed by the same tribunal has been quoted. And thereafter, my lord, internal page 3, para 4. By following our decision, we set aside the impugn order. None of our cases have been considered. Our ground, Lordship, may kindly see.
No, but if it's a covered matter, that's what happens in tax matters. It's covered. If the point is covered,
Only
then
one submission, my lord. Lordship, may kindly see, my lord.
What did you do in that case, sir? That single enterprise, what have you done?
That, my lord, no, our cases that is covered under the Vandana Global case, my lord. That the learned commissioner has taken note of that. Lordship, may kindly see.
No. Against the judgment in single enterprises,
my lord.
What has the department done? It's a Delhi tribunal.
That has been quoted. Lordship, may kindly see page.
Correct. What have you done, sir, as a department? Have you challenged it further?
My lord, that instruction.
You have to find out that, sir.
But this is a larger bench judgment, my lord. Lordship, may kindly see the commissioner has taken note of it. Internal page 11 of the.
They're all tribunal judgments at the end of the day. If this has been challenged or not, you have to tell us.
May I let notice is going to cure all the defects. Let notice go.
First, find out what has happened.
All right. Lordship, may call it the first week of January.
Stamp report now be prepared since counsel for the appellant states that the deficit paid court fee is paid today. Paragraph, counsel for the appellant also needs time to inform the court whether the department had challenged the decision of the Delhi bench of the Sistat in single enterprises private limited versus Commissioner of Customs and Central Excise, Raipur, 2016 341 ELT 372, bracket TRI-DEL, bracket. List of 10th April.
Item 25. Item number 25. Item number 26.
May please your lordship. This is a CELTAS revision application filed by the petitioner as substantial questions of law is out of the impugned second appeal order dated 27/12/2019 by the Annexure 7 mailer at page.
What's the delay?
At page mailer 126 to 133 mailer. The questions has been framed at page 7 mailer. This matter mailer appears today's list for orders mailer. Only because a memo has been filed by the petitioner regarding the removal of defects as per SR on limitation matter is at flag X mailer. I would like to place this said memo if your lordship permits, mailer.
Two days delay.
Mailer.
Anyway, it's 2 days delay, sir. Carry on with the main matter.
My lord, there is no delay, my lord.
That's what I'm saying. Carry on with the main matter.
My lord, main matter is that the substantial question of law arises out of the impugned second appeal order by Annexure 7, my lord, at page 126, 133, my lord. The questions has been framed at page 7, my lord. I would like to place the questions which I have framed, my lord, which finds place at page 7 to 9, my lord. May I place, my lord? Question of law arises out of the impugned second appeal order dated 27/12/2018 passed in essay number so and so. Whether appeal filed through the establishment officer number 1 of the commercial tax department for the year so and so is initiated or not. That I want to press, my lord, only main questions I have framed, that is at page 9, my lord.
What's the tax effect, sir?
My lord, page 9, questions.
Are you able to hear us?
My lord.
Are you able to hear me, sir?
Yes, sir.
What is the tax effect?
Tax effect now is only 95,000 some odd.
No, 35,000, sir. Just come to your questions for it. It is 35,329, sir.
The total demand now, after the disposal of the second appeal, the first appeal, it is now comes to 95,000 some odd.
Where are you getting that, sir?
I would like to draw your lots of kind attention to
Page 111. The
111.
first appeal order.
First appeal order.
First appellate authority has reduced the demand, and that has been confirmed by the Land and Sales Tax Tribunal.
Oh, I see.
That is at page 111, madam, which comes to rupees 95,289, madam. What happened, my lord? I want to submit before your lordship that what did the Odisha Sales Tax Tribunal has did only because he has not taken into consideration of the written submission filed by the petitioner by annexure 5 and 6, my lord. As would be evident from the ordering portion of the impugned second appeal order, my lord. The ordering portion of the said order is at page 129, my lord. Ordering portion of the second appeal order, which finds place at page 129, internal page 4, para 8, my lord. And the petitioner, in course of hearing of the second appeal, has filed two written submission before the Odisha Sales Tax Tribunal, which finds place at page 116 to 120 and annexure 6, 121 to 125. Written submission has filed in course of hearing before the Odisha Sales Tax Tribunal. It has not been taken into consideration. He is obliged under law to give specific finding on each of the issue raised in the written submission, my lord. I would like to draw your lordship kind attention annexure 5 and 6, my lord. Written submission has been filed before the tribunal, and tribunal has not taken into consideration of this person. Specific finding has not been recorded, madam. That apart, I want to submit before your lordship what the Odisha Sales Tax Tribunal has did. They have
no notice went in this revision, sir, so far.
My lord, no.
Notice also has not been issued.
My lord, obliged.
All right. Notice returnable. 27th April. He accepts notice.
My lord, petition may be protected, my lord. I have filed an interim application.
No, think, sir, we are in 2022. For 3 years, nothing has happened.
My lord,
how will something happen now? Nothing will happen.
My lord, obliged.
Item 27.
All right. LCR will requisition.
Item 27.
None appears dismissed.
Item 28.
Same order.
Item 29.
Same order.
Item number 30.
Same order.
Item 31.
31, my please, Your Lordship. Substantial questions of law in this case, my lord, is at page 9, my lord. May I place it, ma'am? May I place it, ma'am? Page 9, my lord.
It's a delay. No. Zaya is allowed. It's a notice returnable. 27th April, he accepts notice.
Item 32.
Yes, in this case, I have rectified the defect. I have solved the copy to the. Now, the limited issue is that during the warranty period, I have replaced some spare parts. Your Lordship has granted the interim direction since there is a decision pending before the larger bench. I've annexed the Tata Motors case.
Same order. Only the name of the council will change.
Interim.
No interim, sir. Nothing.
There is a demand of 11 lakhs.
Never came up even once in 3 years, sir. It's all sleep mode. Only we are bothered. Nobody's bothered. Yes.
Item number 33.
May I please, Your Lords? My Lord, this is relating to Section 2J of Orissa Anti-Tax Act.
Yes. All these cases.
This matter has been
all these
taxed WPC number 21892 of 2012.
12.
That will come up on 6th February.
February. All right. List along. All right.
On the, my Lord, the dispensing with.
Dispense with.
Dispensing.
That IA for dispensing with. Delays how much?
3, 4, 5. Delays 6 days.
6 days. Delays condoned. All right.
Only 6 days.
Item 34.
100% success, sir. Both applications allowed.
Obliged. Great obliged.
All right.
Great obliged.
Item number 30.
May I please, Your Lordship?
Yes.
Copy notes are.
My Lord, questions of law at page 5, my Lord. B, my Lord, capital B, whether the tribunal is justified in holding that stone chips, metal, etc., do fall under entry 59 of the schedule appended to the OIT Act. Similar matters have been fixed to 19th April, my Lord, in WPC number 21735 of 2017.
All right. List along with 21735 13 on
19th April, my Lord.
19th April.
My Lord, 67 also same matter.
All right.
Item number 67, my Lord.
All right.
Copy may be.
All right. Notice he accepts notice, copies be served. All right.
Item 35.
May I please?
Copy.
Yeah, we should notice so the copy will come to you.
35.
35, Your Lordship, the question of law frame in page, start from page 6. Dissolution input tax credit. Dissolution input tax credit during the unregistered period, but the rules 11.4 says prior to 3 months. If you have purchased, it should be considered the IPC. But that has not been considered by the SCU nor even by the tribunal. And second one question is imposition of penalty after the amendment 2-time penalty.
What's the tax effect?
Tax and penalty up to 92,094. All right.
Delays condoned, dispensed with, that both applications are allowed. You see notice returnable.
5 days.
Item
condoned.
Item 36.
Your Lordship, may I kindly turn to page 20 for the question of law, Your Lordship. There is an amendment 2015.
119 days delay.
Your Lordship, Your Lordship, your delay is.
Leave the question open, sir. The delay is not properly explained. Delay application is dismissed. Consequently, the petition is dismissed. However, the question of law urged is kept open for being considered in some other appropriate case.
Item 37. May I please, my lords? But here the question before lordship is at page 13, my lords. And the question number A and B are covered by your lordship's judgment, my lords. So far defect is concerned, my lords, before I address your lordship, my lords. So one is prayer not given. It's, your lordship will find this is under rule 42, rule 52A. It's a application, form 43, XL Roman 3. And there is no prayer, in fact, available here. But whenever you raise questions of law for lordship, your lordship answers that, and that can be equated with. So therefore, your lordship always dispense with that. It may dispense with. And the second defect is, I have filed a miscase application to dispense with annexure 1 and 2. These are not improved order. I have given original, but those may be dispensed. Those are given the original for the authority below, minors.
All right. The same Bajrang Bali, that DIC certificate.
Yes, minors.
Binding on the sales tax authority.
I am giving to your lordship, minors, judgment of my lord, minors. Question number A. Though minors may address lordship, though the London tribunal has set aside the matter, but while setting aside, the observations are findings. These are not observations. All are findings, minors. Direct findings, and nothing can be done by the asking officer. And question number A, minors, at page 13, is covered by your lordship's judgment, minors. One is question number A is covered Upahar Udyog. I have also marked the paragraph number 16 and 18. And question number B is Bajrangiwal, and your lordship have relied upon Bhadiral chemicals case of the Honorable Apex Court.
Right.
That is in paragraph 17.
Anyway, notice has to go now.
Your Lordship, at page 50 also, at the time of remanding, the London Sales Tax Tribunal has given all the observation, Your Lordship. So, Your Lordship, it is a remand, Your Lordship, with the observation. And hence,
these are not observations, they are findings. Let me now bring my lord's attention to that. Let me take my lord's attention. Your lordship may kindly see now.
But anyway, let's issue notice. Notice returnable. 20th April.
Item number 38. Let's now it is set aside, so no manner. Deeply obliged. Item number 38. So dispense with us, sir.
Yes. Dispense. I is allowed to, right.
Item 38.
I'm appearing for opposite pet number 1, the State Information Commission.
Who's for the petitioner? None appears for the petitioner. Dismissed.
Item 39.
None appears dismissed.
Item 40.
May I please, Your Lordship? Dear my lord, this is the matter, my lord, for reconstitution of the appellate authority, State Pollution Control Board, my lord. Last occasion, Your Lordship has added on the matter, whether government has taken any steps with regard
to... I think they have.
Yes, Your Lordship.
Where is the notice?
That is the instruction. I am sending the letter of the comment.
Yeah.
But what I find, he has prayed for chairman and vice chairman, both the posts. But what instruction I have received, that is only for chairman, Your Lordship has appointed my Lord Justice B.R. Shanagi. And so far as vice chairman is concerned, perhaps that is not, that is pending or something like that.
What is happening here, my lord? 4 administrative members, they have extended the inner, my lord. But the quorum says that, my lord, at least 2 members, in which 1 judicial member should be there. So
that we have appointed already, sir. You can show him, I think.
Chairman is more or less appointed. Only the approval is required from the MOEF. I'm sorry, Law Ministry of Government of India. And
Government of India has to concur.
Yes.
Oh, I see.
Till then, my lord, at least
the chairman is concerned.
The tenure at least should be extended, my lord, for the period, because
everything is there. The High Court's recommendation, everything is there.
What about the instruction vice chairman?
That is not there. It's my direct. I will take instruction.
As far as the post of chairman is concerned, the recommendation made by the High Court
is now in the final stage.
You say, as far as the post of chairman is concerned, Mr. Mohanty informs the court that The response of the central government is awaited on the recommendation made by the High Court. Paragraph as regards Vice Chairman, the post of Vice Chairman, he needs some more time for instructions.
So item 37, I filed one IA. I'm praying for setting the stay of that order, because unless the order is set aside, if it is set aside.
You just issue notice on that, sir.
Set aside on IA also. Because otherwise.
Notice on the IA also.
Otherwise, we infructuous.
No. So both on the main petition and the IA, notice return.
My lord is fixing.
As far as the post of Vice Chairman is concerned, he needs more time for instructions. Given a date, right? List on
2nd week.
January.
Obliged.
I think give it back.
I will take that.
Item 41.
My lord, this application concerns the appointment of a member in the Odisha Human Rights Commission.
That is also the same instruction my learned friend has received, that I am to intimate the necessary steps been initiated for filling of the said vacancy, and government orders regarding the same is awaited.
My lord, the Honorable Supreme Court has set down 3 months.
Government, needs some more time for instructions. He states that the proposal is already in process.
Initiated.
And the proposal for filling up the vacancy in the post of member, Orissa High Court Human Rights Commission is in progress. He's under process. He needs some more time for further instructions. List on. Look at this. We have some huge batch. 1st February.
First. 42.
Your Lordship, my lord. Now the municipality has already restored the water supply Saturday, my lord. Last Saturday.
In the meantime, I have filed the petitioner confirms that the municipal authorities have restored the water connection, and affidavit in this regard has also been filed by the CMC. No further directions are called for, the petitions disposed of.
Item 43.
Nana, please dismiss. Oh, pass over, sorry.
Item 44.
43, man. 40. Item 40.
Yes, correct.
It's a public interest litigation, my lord, with regard to selection of NGO for running the hearing impaired schools and physically. So, my lord, there the expression of interest was invited, pursuant to which 5 persons have participated, and there is a eligibility criteria. I have mentioned in answer 1, page 15, my lord. And contrary to the said eligibility criteria, my lord, they have given appointment to some other person. He has no registration and all that. So that is what the challenge and bring to your lordship's notice, my lord.
My lord, the appeal from the RTI is pending. They have filed an appeal.
No, RTA is something else.
So they did not supply, my lord.
This is about selection of NGO.
Right, but the allegation has not been substantiated by any pleadings. So as to say that they are merely saying that we don't have the, as in the so-called applicant doesn't have the relevant certificate.
That is there in.
Now for that they have sought an information inquiry.
You can answer, your records are with you.
Also, my lord, there's one point. So-called applicant has been selected. The process involves 5 stages. If my lords may have.
So I'm going to record that you do not wish to file a counter and straight away I want to argue the matter.
No, ma'am. We will file counter.
All right.
Just bringing it to your attention.
All right. Notice, he accepts notice. Reply be filed within 8 weeks. Rejoined above the next date. List on 29th March.
Item number 44.
44, may I please, my lords? There is a government land, my lord, kept for gauging the cattle, my lord. In that land, there is some anti-social constructing the temples in the guise of temples and the commercial establishment. That is, my lord, they cross over the point, my lord.
What are the names, sir, of such persons? Can you give us the names?
Some persons of anti-social.
They have names or they don't have names?
They have names, sir.
What are those names?
In this regard, I have also represented to the collector and the.
Have you named them in the representation?
No, I have not named them. But
you should, sir. It's a good habit. Develop these good habits. Whomever you want orders against, name them so that they also know. Authorities should also know.
If my lord permit me, I will.
Always. We fully permit you, sir.
Ma'am.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a proper representation naming the persons allegedly who have encroached upon government land, and after following up on such representation to seek appropriate orders in accordance with law. Post office withdrawn with liberty is granted.
Interim application is there. They are constructing, my lord.
You don't delay it, sir. Now correctly name all of them and please do it.
Obligement.
Item 45.
Well, on the basis of the petitioner's prayer earlier, by the order of the Honorable Court, the land encroachment case is initiated against the OP number 4. So he lost his case before the Tahsildar and sub-collector.
Numerous defects, sir.
My lord, I pray.
No, there are numerous defects pointed out by the registry. You want to cure them, sir?
My lord? Yeah,
many defects are pointed out. Do you want to clear up? Remove the defects?
I'll remove the defects.
Or defects we removed within a week, list thereafter.
Published.
Item 46.
So, in this case, Lords, the case of the petition has already been decided by your lordship while passing interim direction with some observations, with the consent of my friend who produced a copy of letter of the department, Lords. But the issue involved in that case was 402A declaration form. The provision, as per the amended provision, procedural nature, Lords, there's only single declaration will be given for the purpose of the transportation of goods. And when we are carrying goods which we are bringing by. So
nothing survives in this petition.
Yes, now it has been decided. Your lordship may kindly see the miscase order. Your lordship may kindly reproduce, and the liberty which your lordship granted, with that liberty matter will dispose of. It's there in your lordship brief.
14th January.
14th January 2015. My lords may kindly see.
All right.
Your lordship have clearly mentioned everything, lords.
All right. In view of the order passed by this court on 14 January 2015, no further directions are sought. Are required. The writ petition is disposed of in terms of the directions issued in that order. All right.
And liberty will be granted in case of any future difficulty. That also.
Right. If any cause of action arises in future, to be open to the petitioner to seek appropriate remedies in accordance with. All right.
Deeply obliged.
All right.
Item number 47.
My lord, 47 is we have challenged the assessment order. Liberty will be granted to.
All right. Counsel, the petitioner seeks leave to withdraw the present petition. Liberty to challenge the impugned assessment order in accordance with law by way of a statutory appeal.
So delay may be.
If such appeal is filed not later than 1st February 2023, accompanied by an application for condonation of delay, citing the pendency of the present petition as a reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any matter. The originals of annexures be returned subject to being substituted with attested photocopies thereof.
Deeply obliged.
This post office withdrawn in above terms.
Item number 48.
My lord, I'm praying Passover, my lord, in this matter.
Your lordship, in this copy has not been
The
served.
copy has been served to the respondent number 1 directly by hand, my lord. I am bringing the record, my lord.
Item 49.
Item 49, your lordship, there is a defect in this matter.
Defects be removed within a week, list thereafter. All right.
Your lordship, kindly hear it after vacation, your lordship.
After a week means it will go after vacations.
After 15th of January, your lordship.
You remove it, madam, and then it will be listed only after. We have not fixed a date.
Obliged, your
All
lordship.
right.
Item number 50.
My lords, I will remove the defects within a week.
All right. Defects be removed within a week, list thereafter. All right.
Item 51.
I'll remove the defects and access.
All right. Defects be removed within a week, list thereafter.
Okay.
Item 52.
May it please your lordships.
Your counterpart is very unhappy you're not serving copies on him, sir.
No, I have served, my lords.
On whom?
I was while sitting here, I was guessing whether I am safe or not, or whether I am going to be guillotined. My lords, after some time, my guess was that I am safe. My lords, here I'll give a date chart for your lordship's kind attention assistance, my lords. Annexure 3, an assessment order for 15-16 was completed on December 2017, my lords.
Right.
22nd. Then this was subject to revision, my lords, by the Commission under Annexure 4. Annexure 4, the Commissioner said that the order of assessment passed under Annexure 3 is erroneous and prejudicial. Thereafter, my lords, it went to the National Faceless Center. National Faceless Center, they passed an assessment order presuming me that I am of Chennai.
Oh.
Lordship, remember last year, and Lordship asked me a specific question whether I belong to Orissa or not. Then I came before Lordship. Lordship quashed the same by Annexure 5 at page 43.
Right.
Lordship said that this is in violation of 144B, and on 6/10/2021, this order was quashed. Then, my lords, under Annexure 1, I immediately
wrote a letter,
communicated it electronically on 12/10/2021.
Right.
That sort is there, my lords.
Correct.
After that, my lords, waiting after 1 year, that is in violation of 153(6) of the IT Act, which says that after expiry, 12 months, he has to complete from the date of the order which is received. I am just placing that. So you may kindly see 153(6).
Same question.
6.
So we've somehow
nothing.
I've accidentally read the last date of your chart.
Oh, my lords.
Then what is the question to ask to be answered now? You know.
Oh, anticipating that, my lords, about the alternate remedy.
Correct.
My lords, here, my lords is absolutely, lords, you always ask me the same question, my lords.
Yes.
But here,
yes,
it comes under the exception.
Why?
Exception is that he has opted. I'll just point out one thing before lordships guillotine me.
Not me. Justice Raman is not happy at all. He has given such wonderful judgments and you're not following that.
Which judgment, my lord?
All alternate remedy.
Alternate remedy? My lords, lordship knows alternate remedies, there are series of judgments.
Correct.
Series of judgments.
Correct.
But so far as the other party is concerned, in favor of the assessees are concerned, my lords, there are also judgments.
Right.
And which says the last judgment, which found that Chabildas Agarwala, where the Supreme Court has made 3 exceptions.
Right.
If it is in fraud, order is passed in contravention of the provision of the Act, then certainly a writ court is capable of entertaining.
Capable of doing so many things, sir.
Beg your pardon, my lord.
Capable of doing a lot of things.
Yes. Supreme Court
Whether
says
we
many
should
things.
do it or not is the question.
My lords, here. What I pray, my lords. Now, I'll just point out one thing. Thereafter, Lordship may, I'll place my Lord's page 54.
Yes.
The so-called notice.
Yes.
Sorry. Page 56. It starts from page 55. Annexure 8. Lordship may, I'll invite your Lordship's kind attention to this one para. Regarding your objections regarding issue of notice under section 142(1) of the Act, the Honorable High Court has not quashed the order. So under section 263 of the Act, according to para 4 of the order, the Honorable High Court has set aside the assessment order and given liberty to the department to decide the case as per law. Where he got it, my lords? Where he got it? That is the question, my lords. If he was so much anxious of that, he could have come to the court. And this order was passed before the all the parties. You cannot assume. And he said, my lords, aside means cancelling as per the Black's Law Dictionary. Then, my lords, the said order has been received during November 2021. He has to pass the order by 31st of November 2022.
In Delhi, I found that some of the orders passed by the Commissioner of Income Tax Appeals are excellent.
Yes.
They discuss all the law.
Yes.
Discuss even commentaries.
Yes.
They're very, very capable, sir.
Correct.
CITA, this kind of argument they can appreciate a lot.
CIT appeal.
Yes. Some of them are very good, sir. Some of them are excellent.
But I have got an excellent here, my Lord Chief Justice.
No. If everything has been happening here, if everything's happening here, then why should we have CITAs at all? They should also be given a chance.
My Lord,
they also want to hear these kind of good words from counsel like you.
My lords, when
please give them a chance.
My Lord Chief Justice is there, why
they'll get encouraged. See, they're already doing a lot of hard work. The appeals filed by Mr. Rai. Occasionally, Mr. Rai should also tell nice words about them. Occasionally, Mr. Rai should say nice words about them also.
My lords, there is no opportunity. It is only faceless, my lords. Had that been
send email, sir. Even by email, they'll appreciate it.
No, my lord, they will never appreciate. Unless it comes to the tribunal.
Correct.
No, my lords. It is the thing, my lords.
Yes.
Lordship may kindly see the provision 153(6). What I pray, my lords. Now, 53(6).
Yes.
Nothing contained in subsection 1 and 2 shall apply to the following. Where the assessment, reassessment, recomputation is made on the assessee or any person in consequence of or to give effect to any finding or direction contained in an order under section 250, section 254, section 260, section 262, section 263, or section 264, or order of any court in a proceeding otherwise than by way of appeal or reference under this Act, or on or before the expiry of 12 months from the end of the month. Here it has been communicated on 12th of October and the ends on 31st of October. Limitation starts from 1st of November. Now, the opposite party says, as your lordship have seen, that he has received on in the month of November. On which date? On which date you have received?
Yes.
On which date? I don't, Lordship, what I suggest, Now it is year ending.
Year ending, no.
Year ending, my lords.
Not even near lunch. So,
my lords.
we are only going minute by minute now.
Minute by minute. My lords.
Year ending is still far away.
4 days, my lords. All is well which ends well, my lord. What I pray, my lords.
Yes.
Lordship may issue notice. I am not asking for any stay. Notice on stay. And let him say.
But the younger members of the bar should watch how persuasive you are. You don't give up so easily.
I am not at all persuasive, balance. I am constrained because I abstained for a few days. Less I will be guillotined.
I hope you watched the football match yesterday.
Yes, yes.
There's a cliffhanger.
Yes, yes. Cliffhanger. Right.
Yes.
There's a good picture also, cliffhanger.
Yes.
So let him say on which date.
Yes.
Then I will give up the case.
Right.
Let him say that.
So now only question is, you want time for filing the appeal or not?
My lords. Appeal. My lords, appeal. Here, my lords. That is your lordship's prerogative.
Not mine. Statute says that, sir.
My lords, statute doesn't say that.
Yes.
Yeah, there are some judgments. Of course, your lordship, my lord chief justice, is well aware of the judgments. And I don't want any fag on the year. I'll be sent back to the.
No, why, sir? They are excellent officers working so hard, sir.
But your lordship will see that national faceless.
Yes.
And sometimes now I am also hearing it has come that they are going to also for
artificial intelligence.
Artificial
intelligence. That's your new challenge. It's going to happen.
Yes. The tribunal is going to be faceless.
Okay.
So what I pray, my lords, if your lordship is not inclined,
yes,
have it in the new year.
No. So what you say, the counsel to the petitioner seeks leave to withdraw the present petition with liberty to approach the appellate authority in accordance with law, if such appeal is filed not later than 1st February, sir. 1st February 2023.
6th February, my lords. 1st February. My lords, and also lordship may give liberty to file a miscase for interim stay.
Of course.
Before that,
suppose we don't give you the liberty, you think you will not file?
No.
You will definitely file.
I will file.
Yes.
What I expected, same thing happened.
See, you got a lot of foresight, sir.
But previously I was thinking that no, I'm safe. Now it proved to be wrong.
You're still safe. You'll only come back after a few years. You say a complete application for condition of delay.
At least, till the disposal of the stay, I may be protected.
No.
Till the disposal.
Same thing. So, same orders as earlier. Is there any originals that you filed, sir? No.
No, in appeal matters only the demand notices to be income tax, unlike cell tax.
Court clarifies it is not expressed.
Lord, I am appealing for this.
Item number 53.
It is amazing that the petitioner labors very hard, but the opposite party takes.
Sometimes you also take the chance.
So, I am asking, but I am wishing to go to that side.
And vice versa.
My task will be easier. So oblige, my lord. Oblige.
All right.
Item number 53.
May I please your lordship?
Yes.
In this case, lords, challenging RIA's notice issued under section 158 capital A B lords.
Yes.
For the assessment year 2014-15 after a period of 6 years from the end of the relevant assessment year, lords. Lordship, this is clearly barred by limitation.
Well, 148D order, sir.
Yes, lordship, I am challenging to 148A with similar, identical order, lordship, 28th February 2020.
What I This was prior to our batch matter.
So prior to your lordship batch order.
So now that batch is our new batch order is the order now. Governing order.
This is the order, my lord.
Now you people have a copy of the order. The other day, nobody had copy of this order.
Yes, ma'am.
So same order, sir.
My lord, I am giving this.
In view of the order. 1st December
That is-
2022.
Yes, my lord, I have.
Petition civil 9191 of 2022 bracket Kailash Kedia versus income tax officer. The present petition is disposed of in the same terms. All right. Now people have to stop filing, sir.
Yes, sir.
Item 54.
So 54, my lord, relates to interest on entry tax, my lords. These similar matters are being posted to 2nd of February 2023, my lords.
All right.
And I'll just here, my lords, there was a demand raised of 36 crores 41 lakhs 13,766. And your lordships were kind enough to grant me 36 installments. Page 33, if your lordship would kindly turn. Along with your lordship got it, no? Yes. So we were asked to pay this 36 crores 41 lakhs 13,766 along with in 36 installments along with interest. If your lordship would turn to page 34, lords. I have already cleared the entire amount in my 36th installment.
Okay.
That's page 34, lords.
Right.
And the interest accruing thereon amounting to about 14.37 crores. So my only humble submission, lord, is that your lordships is whether any interest will be payable by the petitioners prior to the Honorable Supreme Court's judgment, lords, that is 28th of March 2017, and what would be the rate thereafter, my lords, which is being considered by your lordships.
No, but I think the usual order is for period thereafter you have to pay anyway.
No, lords, your lordships are deciding it. Because in Bajaj Autos, your lordships have held, lords, that prior to the Honorable Supreme Court's judgment, no interest is payable. And that was pressed and it was kept for the 2nd of February, my lords. In this case also, my lords, your lordships have also given me the leave to raise this issue, my lord, and it will be dependent on the batch case.
Pre-period, I can understand. For all the period earlier to...
This period, my lord, is 1/4/2010 to 30th of April 2017.
So it's only 1 month.
1 month is post.
That's what.
So the major part of it is pre.
That's right. So the post you pay all his...
No, I've already paid, my lord.
Post.
Post also, my lord. 40, because 36 crores somewhat.
No, interest was paid.
Interest was also paid, my lord.
That's what he says.
But I'm submitting your lordship. Your lordship may kindly turn to the prayer. In the prayer, the petitioner prays that to waive the levy of penalty pertaining to the period 1/4/2010 to 30th June 2017. Now, your lordship may kindly turn to Annexure 3, page 30. Here, the same challenge is there.
Although he has prayed this, he says and will record a statement for the period after the judgment of the Supreme Court up to 30th June 2017, he has paid the interest, he says.
This honorable court, your lordship, at page 33, the paragraph...
Mr. Have you heard my lord's query?
Your lordship.
So post, do you have any objection?
No.
Post.
And your lordship will appreciate the rate of interest which is subject matter.
In your lordship has already directed subject to result of the writ petition. Already directed at paragraph 6. However, we make it clear that interest on the aforesaid amount for the period from 1st April 2010 to 30th April 2017 will be subject to the order to be passed on WPC
So
number.
all that, my lord, I'm praying. All that I'm praying, let this matter be tacked up to the batch so that I'll have an opportunity to address your lordships.
All right, simple. That's all.
That is the only thing, my lords. Since the revenue is not prejudiced in any way.
6th February.
It's on 2nd of February.
2nd February. List on February along with
WPC 13736 of 2017.
13736 of
736.
Yeah, of 2017. Got it.
Obliged. I'll have a chance to address your lordship.
Yes.
Much obliged.
All right.
Item number 55.
Your lordship, I may be permitted to withdraw this petition with the liberty to approach this honorable court if the cause of action survives.
Review petition serve as liberty. Counsel, the petitioner seeks leave to withdraw this review petition, dismisses withdrawal. Right.
Item 56. Item number 56.
My lord, as per the last order, my learned friend has provided a copy of the persons who have received the compensation and who have not allegedly received the compensation. I have to seek instruction on this, but I have sent it to the concerned officer. I have not received the instruction because they have to examine the year-old
records.
case.
All right, Mr. Mohanty needs some more time.
May I suggest one thing? Your Lordship may direct that the sole grievance is now they are claiming that some of the persons have not received, some have not received. Let them produce all these records before the district social welfare officer, who is the approving authority and under the collector, and he will take the necessary action. And if he is agreed, he will come again for the. There is no meaning in keeping this matter pending
since 2012, Mel. 10 years is
within a time-bound period. If you are agreed, then you come.
Till date not rehabilitated. As per the atrocity act.
No, he's suggesting that you can go before that officer and time-bound by ask them to dispose it off.
With this particular which you have
provided. Only those individuals who are still agreed will come before the court, not everyone.
Yes, exactly. Because all other issues are now substantially become redundant. Only this regarding compensation.
Family members. All the petitioners are one family member.
So it'll be easier, sir. We'll give a time-bound direction, be over there. You say, apropos the chart submitted by learned counsel to the petitioners, showing the amounts still to be received by some of the individuals. A suggestion, Mr. D.K. Mantil, an additional government advocate, that a time-bound direction can be given to the district social welfare officer, Balangir, to examine each of these.
Yes.
And send a appropriate recommendation if a case is made out to the collector.
And each of the persons who have received and not received, according to this list, he will check the list and verify the list.
Each of the persons mentioned paragraph, it's accordingly ordered that each of the persons mentioned in the chart submitted by the petitioner on the previous date will appear with the district social welfare officer on.
My lord, there are so many persons. There are so many persons.
No, I know. Yes. On between some dates, we'll say.
Yes, yes.
Between 6th February and 4th April, or 3rd April, 6th February and 3rd April 2023. On dates to be intimated to each of them by the district social welfare officer, at least 10 days in advance.
Yes.
They will appear with all the documentation they may have in support of their respective claims. We'll stop after examining each of the claims and after hearing the individual. The district social welfare officer will make an appropriate recommendation to the collector.
To the collector for payment. To the government, I'm sorry.
To the government. Within a period of 8 weeks thereafter. Full stop. If aggrieved by
any individual case.
If agreed by the decision of the government, which will be communicated to such individual within a further period of 8 weeks after the recommended receipt from the district social welfare officer, it will be open to such individual to seek appropriate remedies in accordance with law.
May I request your lordship to communicate this order by the registry to the collector Balangir and district social welfare officer Balangir.
All right. Copy of this order be communicated both to the district social welfare officer as well as collector Balangir by the registry for
necessary compliance.
Yeah, compliance.
And fixed the date.
Disposed of. My lord, disposed of.
Petition is disposed of.
Disposal?
Yes.
All right.
My lord, as per the Atrocity Act, and
that is the case. That is the case.
Yes, and Ministry of Social Justice Empowerment notification.
No, they need not be involved in this, sir, at this stage. If nothing happens after this, all this, then you can bring them in. All right.
Item number 57.
Paltry amount, this is 20,500. I am appearing for the opposite party.
Opposite party. All right. Yes.
Paltry amount, 20,500.
Since the amount is insignificant, question of consideration some other case. The petition is disposed of. The delay is what? Nil. All things over. All these applications. All right.
Item 58.
May I please, my lords? Here in this case, section 43, subsection 5 of the Real Estate Regulation Act 2016 is under challenge, my lord. In the meantime,
it's already covered, no?
Yes, my lord. That I am placing, my lord. Already I have gone through my lord's other judgments
and upheld by the Supreme Court now.
My lord. My lord, yes, I have gone through. So In view of this, I.
Okay, all right. In view of the judgments of the Supreme Court, counsel for the petitioner does not wish to press these petitions. Their petition, this is disposed of, is not pressed. All right.
My only one submission, my lord. In pursuant to my lord's direction, I have deposited 25% of the amount before the appellate authority. That may be.
If you already disposed of, that will now be taken up, sir.
My lord, this order, this honorable court dated 30th July 2021.
In which matter?
This matter. And subsequent order, IA number 9268 2021. They have deposited 25%. The tribunal is not proceeding the matter in view of the interim order. No corrective actions.
No. Now the interim orders are all vacated.
Just.
Yeah. Interim orders are vacated. All right.
It's obliged.
All right.
I'm for the opposite party union opinion.
All right.
Item number 59.
The larger issue in this PIL is providing safe blood by having facility of PCR facility in all blood banks. And way back 2013, an affidavit was filed, but the state is silent on that aspect, my lord.
No, there are some other blood bank matters.
Yes, that is a different issue. That pertains to only one particular issue. I'll give the. That was with regard to transfusion of HIV positive blood. Here also the case is similar.
Antigen
PCR test, my lord.
Yes, here he asked for various other relief. I'll file a detailed because the prior affidavit was filed back in 2013. So I'll file a.
No. So this notice has never gone in this red petition.
Notice was sent and affidavit was also filed.
We have filed our affidavit.
What is that? Let's see that.
2013, my lord.
Yes, 27th of February 2013.
Because this question was raised in the context of HIV infection of a woman who lost her child also. She became HIV positive, my lord.
What kind of an answer is this, sir? What happened to that case?
Yes,
No, you're only saying that since she was not there earlier, why would they get tested? For no reason, why should they get tested earlier?
Yes, Milord.
She developed HIV positive only after the transfusion. So you can't presume that she must have been positive already earlier.
Yes, because at that point in time, since that during the antenatal period, since there was no report suggesting.
Why should there be reports? Unless nobody's going to just go and for fun of it, go get blood tested.
I'll file an affidavit specifically dealing with, because the last paragraph of that report, my lords may see, the committee recommended that with proper identity proof of both the donor sample should be collected and sent to the microbiology department of SCB within 24 hours with proper procedure for further opinion, and the blood sample of the husband of Mrs. Banita Jena may also be collected and sent to the microbiology department, so and so.
Where is this woman now, and what's she doing?
My lord, I will ascertain.
You better ascertain, sir. All this happened quite some time.
My lord,
why are these petitions not followed up by you, sir? This is a 2012 petition.
You
don't even mention for listing.
I filed some memos, my lord.
Sir, I have been sitting here for 2 years. You mentioned so many matters.
Yes, my lord.
You never mentioned this matter.
Yes, my lord. I am sorry, I have not mentioned.
These are matters where if you do not have a timely intervention, everything is lost.
Yes, my lord. I am sorry.
Now, after 10 years, what kind of inquiry will they conduct? Counsel to the petitioner who appears in person needs time for instructions on the current status of the person for whose relief, in whose case, you say about the person for whose instance of contracting of HIV positive through blood transfusion from where the present petition was filed. That is request list on first February. All right. Obliged.
Item number 60.
Item 60, my lords, a directive for a new draft for the core Cuttack City, my lords, recollect. The planning member CDA is in charge of overseeing that. May be directed to file an affidavit to that effect. So whatever instructions we get are getting from him.
All right.
My lord, may kindly see last orders. How many times they have taken adjournment to do this? My lord, I have 2 mandaps, my lord, it is closed. They are allowing other mandaps to run, but I am having parking and everything, but I am being not allowed. My lord, this is a source of livelihood of a person. He has taken a commercial plot. He has developed a commercial building. He has got an approved plan. In spite of due to their lackadaisical approach, my lord, I am unable to run my mandap. But whereas they are giving mandaps in Balubazar where there is no parking area, my lord. The last occasion I was mentioning before your lordship, it is in my area, Lakshmi Mandap. My senior is of that area. I am of that area. Well, they are allowing, they cannot pick and choose between parties. They are giving a mandap where there is not even a parking of one vehicle.
There is one municipal Kalyan Mandap. Municipal, they are charging the user's fee and the trading license, everything. But municipality Kalyan Mandap, they have exempted everything. As a result of which, what happens, the license, everything has been granted in our favor, but people are attracted to the exempted category.
191G.
Yes.
Special provision was state-owned.
My case is that I have parking.
Yes.
4,000 square foot parking I have.
Yes.
They are not allowing my mandap. It is in CDS sector 11.
Yes. So, Mr. Nayak, you're being very unfair to them.
My lord, his case, my lord, has been rejected. There is an additional counter affidavit that I have filed.
When?
There is an inspection report. This is in writ petition number 23063 of 2016.
Oh. Is he aware of it, Mr. Bose?
Yes, my lord, I am challenging that. I am challenging that.
Okay. Supposed to have obtained a non-existent certificate from CDA.
Their application, my application. I am challenging that. That's why, my lord, I have filed 2 writs, 20403 and 23063. That is under challenge.
No, but if you do not respond to this additional affidavit, then you are accepting
that
everything.
additional affidavit they have not served me. But they have rejected my application, which is under challenge before your lordship.
No. Additional affidavit.
Additional affidavit, they have not served the copy. They don't serve any copies to us.
2017 matter, my lord. I'll serve another copy.
Copy of the additional affidavit. You see in writ petition civil 23063 of 2016. Copy of the additional affidavit dated 25th July 2017 be served on counsel for the petitioner forthwith. Is permitted to file a response thereto. But all this happened 5 years ago.
My lords.
Let them make a new inspection.
It stands rejected since then.
Because of the
inspection report to this.
You want to inspect it again or 5 years? In 5 years, so many things may have changed.
Well, he has not rectified anything of the defects that have been pointed out in the inspection. I'll give him a copy.
You file an affidavit.
Floor. And now I am having 1 floor.
So anyway, you file a response and then we'll see. In the main matter, you say Mr. Nayak states that some more time is needed for placing before the court the draft regulations, is it? No, not before
my
the
lords,
court.
the planning member CDA is to be directed to file an affidavit because my lords is granted several
states that the planning member of the Cuttack Development Authority is overseeing the exercise of drafting of new regulations. So a direction is accordingly issued to the planning member CDA to file an affidavit before the court indicating the current status of the framing of new regulations. Full stop. The affidavit be filed at least 1 week prior to the next day. 1st March.
I think CDA is not a party. I think CDA is not a party. This order may be communicated to the CDA.
Copy of this order be
CDA is
communicated
party
to the
in my case.
All right. Planning member
In
CDA.
that case, in which order was
The interim order is there.
Interim orders passed already.
Let them file that affidavit so that I can reply to them.
All right. It won't be 1st March. It will be
Nothing on 15th March. 15th March.
Well, let the municipality serve me a copy so that I can file a
I saw
response.
I've already said that.
15th March.
Yeah. Yeah, but let that come along with this. The next day of 5th April 2023 is cancelled. All right.
Item 61.
May I please, my lord? My lord, on the last occasion, my lordship has directed the state to file a counter in respect to the solar operated and battery operated.
In this
boats.
case, I have filed a petition. I have filed to seeking some more time for filing of that affidavit. And IA has been filed to that.
All right.
Lordship, in the meantime, the Wildlife Division and the Fisheries Department, Lordship, they are restricting the movement of the machine boats inside to the water from that Mangalajodi point, Lordship. I have filed the intervenor application. But I pray, Lordship, till they restore that boat as per the government proposal that they will provide the fishermen that renewable energy propelled boat. Till that day, they may not do any restrictions. Problem is that the fishermen are facing difficulties to enter into the deep water.
There is no specific allegation, no petition, no details, only the allegations without any basis.
Lordship, my intervenor application is there.
What is that? Where is that? Where is that?
That IA I have filed. I think that is IA number.
I'll serve the copy. I have
17318 of 2022.
My IA is 3148 by 2022, Lordship. I'm serving the copy. I'm serving the copy, let them take the control. The instruction.
This is government's IA. All right, 17318 of 2022 for the reasons stated therein. Time for filing a detailed counter affidavit as regards the possibility of solar or battery operated boats is extended till the next date of hearing.
Lordship, I'm serving the copy.
Where is your application? No, even we don't have, sir.
Court don't have.
Court file any file for
court.
You better bring it up.
Lordship.
But list on.
But my lord, this is the right time, my lord. The migratory birds are now they are migrating to the.
Anyway, we're not changed. We're not varied any orders, sir. The older orders are continuing. That's it.
Lordship, in the meantime, they have their channel from that Mangalajodi point to Kalpata and Bhushanpur. So the fishermen, when they are entering, Lordship, they are also following the government guidelines, Lordship.
All right. 14 March.
Bars where they are nesting and resting to that area, they are also operating all these boats from that area in a silent manner.
All right. 14th March.
Published. Item 62.
Yes, please. Yes.
Item 62. May I please your lordship? In accordance with the last order of this honorable court,
yes,
your lordship had directed the state to dispose of annexure 1 by passing a final order. The petitioner is not yet has not yet received the final order of the collector yet. So it seems from the noting that they have passed a final order, but I'm not in receipt of that.
I have written a letter, but no instruction has been received.
All right. Mr. Manti needs some more time for instructions on the final order that is supposed to be passed by the collector on the representations of the petitioner. A copy of the decision be placed on record with an affidavit before the next date. 2nd March.
Much obliged.
All right.
Item number 63.
Your lordship had issued notice. State has filed one counter, my lord. My lord, I have
but we have not received it.
No, I have received. My lord, I have received only on 16th.
No, you are luckier than us. We have not received.
No, we have filed the counter.
Yes, I have.
Lord, it's a PIN. The villagers are before your lordship opposing the grant of sand Sairat lease in my favor.
In fact, before I'm sorry, I'm interpreting my senior. My lord, we are not against, practically not against this. We are practically against the lifting of the sand within the 1 kilometer radius of the bridge, which is likely to collapse due to trucks. Yes.
That is what I was just going to tell, if my learned friend will have little patience too. In fact, they are opposing my grant of lease. My lease was granted on 8th of December 2021. My lease was granted pursuant to the tender and all procedures was granted on 8th of December.
1 year you've been operating it.
I have not operated a single trip. I have not been able to lift because of these oppositions. I have not been able to operate the source. Lord, first of all, they say they having granted the lease, they passed an order that don't operate it because of the objection of the village. Today, the villagers are before your lordship. That order also I am challenging before your lordship in another petition. Today, if your lordship just see Rule 30 to assist your lordship, this problem can be sorted out. Rule 30, sub Rule 3 of minor mineral concession rules. If the grievance of them is that embankment or bridge will be in danger. Kindly see Rule 30, sub Rule 3. Let's have seen that. Lord, I have already deposited 79 Rule 30, sub Rule 3, my lord. Grant of query lease for riverbed sand mining.
Right.
Of 2016 rules.
Correct.
Lord, sub Rule 3 state where your lordship may kindly see the competent authority in consultation with the local official, not below the rank of assistant engineer of water resources department shall work out appropriate safety zone taking into account the structural parameters, locational aspects, flow for carrying out mining operation in proximity with the bridge or embankment. No mining operation shall be carried out in the safety zone so worked out. Lord, my humble submission here would be, my lord, since 1 year I am in limbo. I have deposited 79 lakhs of rupees.
So let them do this study.
Let them complete that exercise. If at all it's falling within the safety zone, let them refund my amount, my lord. Because I am no more interested to do this, my lord. I have huge amount is like.
We can conduct the inquiry. So far as refund is concerned, that cannot be.
We don't know. Step by step.
Yeah, we'll go.
He's anticipating if it's unsafe, then he wants to get.
No, I am bound to. They are bound to refund me because without exercise, if they have leased out in my, they can't withhold my money. 79 lakhs with other expenditure, they are withholding it.
My lord, what I beg to submit, this type of investigation, all before the query was initiated, that there will be a query.
So let them give protection. I'll operate.
No, but what do you say in your counter? We have not got a copy of the counter. What do you say in the counter on this?
This factor has not been answered. What my
so his
because that is not
a bridge. No. The petitioner's apprehension.
Your lordship may direct whether any investigation in terms of that Rule 33 has been contemplated or not. That I will.
Lordship may kindly see the rule order.
And if it is not contemplated,
yes, if it is not contemplated, it will be. But if it is already contemplated, it already conducted.
It has not been contemplated. Rather, Annex 10 at page 98, your lordship will see the superintendent engineer Anandapur Canal Division writes to the Tahsildar Ghasipura that don't allow such lifting of sand within 1 kilometer radius of the bridge and embankment. So if they would have done, my lord, they could have placed that matter. They have not placed this matter.
All right. Copy of the counter affidavit filed by the state be brought in record. Mr. P.K. Rathalan, counsel for the petitioner.
No, it is not opposite party.
No, for the opposite party number.
Well, he's the private opposite party.
Right. No number. Sorry.
Lord, opposite party number.
Opposite party number 6.
6. States that for the last 1 year, despite grant of the lease in his favor of the sand quarry in question, he has not been able to operate the sand quarry because of the opposition of the present petitioners who are villagers. Full stop. He also draws attention to Rule 30 bracket 3, read with Rule 30 bracket 4 of the Odisha Minor Administration Rules 2016 bracket OMMC rules bracket, in terms of which the competent authority, that is the collector,
competent
Tahsildar
is supposed to work out the appropriate safety zone after consulting the local officers not below the rank of assistant engineer of the water resources department before permitting mining operation in proximity with any open quotation bridge or embankment, unquote. It may be noted here that the petitioner's principal objection to the operation of the sand quarry in question is that it will endanger the bridge in the area.
And embankment of the river.
As well as the embankment of the river. Paragraph. It is accordingly directed that if no such study has yet been conducted, the Tahsildar will immediately, in terms of Rule 30 bracket 3, undertake said study and place before the court along with an affidavit, an appropriate report in terms thereof. Stop. If it has already been conducted, then such report also will be placed with an affidavit before the court at least 1 week prior to the next date. List on with advance copies to counsel for the parties. List on. March 20th.
Well, one thing with your lordship's kind consideration. Let him conduct. Well, I am not on that. Let him conduct, but involving the parties. Because
no, sometimes it gets very problematic, sir.
Practically impossible.
There'll be a law and order problem then. You can take it from me. There'll be a law and order problem. It's better than quietly.
Rule doesn't provide involvement of any party.
Unnecessarily tempers will be raised.
Further request to your lordship, this matter be taken up along with WPC 19452 of 2022. I have challenged that superintendent's order here.
All right, 19452 of 2022 on
well, if my senior gives me a copy of that, I can intervene.
So you are not a party there.
No, I will intervene.
Take the number and appear.
Because it's same matter, manner.
You want to keep him company everywhere.
19452 of 2022.
All right.
Well, more the cases, the more the merrier.
Yes.
Item number 64.
May I please your lordship? Millard, this is that sales tax exemption to IOCL project.
Correct.
Which are
I think we can hear it at the end of the board. Let's be done with it because it's gone on for too long. End of the board.
Item 65.
Yes.
65.
Oh, this is something else. None appears dismissed.
Item 66.
In item 66, the petitioner here had challenged the notice of attachment. This petitioner company in the meantime has been taken over by Tata Steel Long Products, and they have identified their tax liabilities so far as the sales tax dues of the state government is concerned, and that has already been paid. I mean, nothing remains outstanding.
All right. In view of the subsequent developments, it is stated that nothing further needs to be done as far as the present petition is concerned. It is accordingly disposed of. Right.
Deeply applied. All right. 67. Item number 68.
May it please your lordship, this is a question regarding payment of entry tax on purchase of scrap materials from the railway divisions, Orissa. So it is single point tax and purchase from local authority who are not liable for making payment of the entry tax. The cover judgments are there, starting from Bhushan Steel and also Sunshine matter, which my lord decided Snow White that railway is to give protection and railway is purchase. I am not supposed to make any payment to the entry tax. It is single point tax. In Snow White case, para 21, your lordship has categorically stated that seller in fact has to pay the tax and it is an identical body and no entry tax is liable to pay. And no objection was made whatever the audit report, and that has been also there. Only this is satisfaction. That is not an issue. And in Bhushan's case, your lordship have said that if nothing has been decided, indicated.
Assessment order has been challenged here.
Assessment order, but it's cover matter.
No,
Item number 69.
My lord.
Challenge has been made to the order of the commissioner, your lordships, wherein the commissioner has confirmed the order of attachment of bank account of the petitioner, your lordship, who was a director for recovery of the outstanding amount of the company, your lordships. In fact, under the statute, your lordships, under the OVA Act, there is no statutory provisions under the Act, your lordship, for recovery of the areas of the company for director of an ongoing company, your lordships. That being the case, your lordships, this order of the commissioner is to be satisfied, your lordships.
It's also already counterfiled.
Your lordship.
Yes, already.
Counter
region also we filed, my lords.
So what's the stand in the counter?
Your lordship, in the counter stand is that the resignation part has not been intimated to the department, your lordship. At page 40, it is at running page 40, your
my
lordship.
lord, whether it is resignation is communicated or not, the only issue to be resolved by your lordships, whether the areas of the company shall be recovered from the director. That to be issue, your lordships.
Correct.
Your lordship, section 71 of the Odisha Value-Added Tax Act, your lordship, also some.
Nowhere, my lords.
Where a dealer 71(1)(b, your lordship. Where a dealer is a firm and an association of person and a Hindu undivided family.
So
and
this is not that. This is the company.
Your lordship. And B is that every person who was at the time of such discontinuance of the partner, your lordship, also
this
the
is not applicable.
same, your lordship. And also the only issue, your lordship, here is that at page 41, I have stated that that neither the application for amendment of RC to the effect of his resignation of Sri Atul Kumar Saxena as director, nor its approval in the instances available in the your lordship.
But it's not relevant again. See, if there's no provision to recover from a director Assuming he did not resign, assuming he continued as a director, can you still recover the company's dues from the director? That's the question.
Your Lordship, that's all.
Director assets cannot be treated to the dealer.
That's right.
So demand is not against the director.
Director, it's against the company. All right. The challenge in the present petition is to an order dated 16th April 2019 passed by the Commissioners of Commercial Taxes, Orissa, Cuttack. Confirming the attachment of the bank account of the petitioner, which was earlier ordered on 16th March 2017. Paragraph. You say, there's no order here. See the original. A counter affidavit has been filed on behalf of the department, stating inter alia that no, just say paragraph. Before that, you say the present petition is by an individual who happened to be an erstwhile director of Messrs. Amcon Engineers Private Limited, the SSC. So for the period 1st April 2011 to 31st March 2012, a demand of Rs 77,350 was raised. For the period 1st April 2013 to 31st March 2015, it was raised under the OVAT Act, you say. The period 1st April 2013 to 31st March 2015, a demand of Rs 1839,139 was raised against the company under the CST Act. Paragraph. On 16th March 2017, the sales tax officer, bracket STO, Cuttack 1 City Circle, issued Form VAT 316, the branch manager of Vijaya Bank, New Delhi, for recovery of the aforementioned sum. Full stop. Instead of issuing notice to the bank account of the company, the STO appeared to have issued notice to the branch manager of Vijaya Bank against the bank account of the petitioner, who happened to be the former director of the company for the period between 16th September 1997 to 15th April 2014. Paragraph. The petitioner on 7th April 2017 informed the bank manager that he had already resigned from the board of directors of the company on 15th February 2014, and therefore could not be made liable for the dues of the company. Paragraph. A similar letter was issued by the petitioner on 13th April 2017 to the Deputy Commissioner of Sales Tax, Cuttack 1, Cuttack. On its part, the company informed by a letter dated 25th May 2017 that the petitioner had resigned from its services on 15th February 2014, and that thereafter he had no link with the company.
Can I point out? Your Lordship, Annexure 2, Your Lordship, may kindly turn to Annexure 2. Annexure 2 is in the name of the company. The attachment notice is in the name of the company.
But the attachment is of his account.
No, Your Lordship.
Your Lordship, and also the commissioner has stated the same thing at page 36, that since the company account has been attached.
No, that's factually incorrect because his account has been attached.
No, Your Lordship, that account, the
This
branch
PAN
manager.
relates to whom?
Your Lordship,
This PAN relates to whom? Company or the director?
this company, Your Lordship.
My lord,
Company, and for that reason, at page 36 of the commissioner's order, Your Lordship, for the last paragraph, page 36, on scrutiny of the RC record revealed that company has its bank account number so and so of Vijay Bank, New Delhi, and the notice dated 26/9/2017 indicating attachment issued by the authorities on this said account number, against which the revision petition of the company has already been rejected by the order dated 9/2/2018.
Sorry to
With regard
interrupt.
to attachment of the bank account.
This is the PAN number, your
company-
lordship. This is the PAN number under which bank account it is issued, my lord.
This, so far as the director, Your Lordship, is absolutely right that so far as the VAT Act is concerned, that a director's account cannot be attached. But so far as the attachment of the company's account, Your Lordship.
We are not interfering with
Your
the
Lordship.
attachment.
Your Lordship.
Paragraph. Against the attachment to the bank account, the petitioner filed a revision petition for the commissioner on 18 January 2018. Full stop. However, the revision petition was dismissed by the order dated 12th February 2018. By order dated 16th April 2019, the revision petition was rejected by the Commissioner of Sales Tax, Odisha. The order of attachment was confirmed and the revision petition was rejected. Paragraph. In the impugned order, reference is being made to section 71 of the OVAT Act, which does not talk of dues of company being recovered from directors, but dues of a partnership firm being recovered from the individual partners. Paragraph section 71 of the OVAT Act is therefore of no assistance to the department in the present case. Paragraph. A perusal of the counter affidavit filed by the respondents, opposite parties, reveals that there is no mention of any power under the OVAT Act enabling the department to proceed, for the dues of a company, against its directors. Stop. In other words, there is no provision under which the department can seek to attach the bank account of an individual director only because he happens to be associated with the company which is in default. So the company is a separate legal entity which can sue and be capable of being sued. Stop. Admittedly, the assessment in the present case is in the name of the and throughout it is the company which has been treated as the assessee and demands raised against it. Stop. While the impugned orders notice the attachment to the company's account, the grievance of the petitioner that as an individual director who has already resigned much prior to the impugned attachment, his individual account could not be attached. He is not even addressed in the impugned orders of the commissioner. Paragraph. There appears to be, in fact, no provision on the strength of which, for the dues of a company, the bank accounts of its individual directors can be attached. Paragraph. Section 51 of the OVAT Act, read with Rule 55 of the OVAT rules, provides a special mode of recovery of outstanding amount of tax, interest and penalty. Stop. Even these provisions do not authorize recovery of outstanding taxes of a company from the account of its individual directors. Paragraph. For the aforementioned reasons, this court is unable to sustain the impugned order dated 16th April 2019 of the Commissioner of Tax Orissa, insofar as the said order confirms the attachment of the petitioner's individual bank account, notwithstanding that he ceased to be a director of the company whose tax dues are sought to be recovered way back on 16 September 2014 itself. Full stop. The impugned attachment order and the corresponding order of the Commission of Sales Tax, Orissa, are hereby set aside.
Attachment order of
the attachment orders will now stand lifted, and the petition will be permitted to operate its bank account as usual, forthwith. Be preferred.
The company's account.
Yeah, that's obviously there. It's only so far as.
Item number 70.
My lord, there is a case against a valuer who has been empaneled by the State Bank of India, OP number 1, and rather they have told that you should finish the indemnity bond. I have come against that, my lord. And let me permit you to tell what is a valuer, my lord. Old Tax Act 1957 has defined what is a valuer. This valuer is a creature of the old tax of 1957.
Who's appearing for opposite party number 1, you are there.
Yes, my lord. I am appearing for State Bank, my lord. My lord, this issue is relating to, if I could to be very short, my lord, this issue was before the Bombay High Court also. This judgment is now under challenge before the Honorable Supreme Court, but there is no stay order. Right. I will only, one part of that judgment only I will show, my lord. What has happened, my lord? What has happened, my lord? The condition that there should be an indemnity bond is for the reason to keep the valuers prompt so that they work as per procedure. Because what we found out, the banks, that there are many inflated values of the collateral securities for which the bank could not recover even 1/4 of what has been lent out. So this is the reason, my lord, this indemnity bond has been kept. My lord, indemnity bond only. If there is a breach only, due procedure has to be followed as per the indemnity bond for the bank to get indemnified, my lord. It is not a bank guarantee that it will so moto come to. Your lordship may kindly see para 39.
No, but you said this is an appeal before the Supreme Court, but there is no stay.
No stay, my lord.
My lord, what is the valuer, my lord?
No. What do you say to this, sir?
My lord, valuer's report is an opinion. Is an opinion, my lord. Once I give an opinion, what they have told, my lord, in independent, I shall duly and faithfully perform and discharge all the duties and all this, and hereby undertake and agree to indemnify you, your success, and assign all time, and from time to time, against all loss, damages, all actions, suits, proceedings, expenses, cost, charges, and demand. My lord, page 10 of my petition. Committed by me, us in performance of the mine, our professional obligation, I or we also hereby undertake, agree to pay to you on demand sum of money, cost, charges, and expenses incurred in respect thereof, and also to pay the interest, all the money that you will be. Is it necessary, my lord? When I give an opinion, is it necessary, my lord, the office head, that chairman of the SBI, was also the chairman of the Bankers Association, my lord, in Bombay.
You have got a copy of this judgment which is handed over?
Yes, ma'am. My lord, this has not been dealt. I have already gone through this. All the courts of the
You're
state.
very quick, sir. You're extremely quick. He just handed over to you. You've said you've gone through it already.
And this is a challenge in the Supreme Court. This is not what I am telling. This has not been told in the Bombay High Court, my lord. All the courts of the country has given a stay order, and this court also. I am obliged to this court. Court has given also a stay order. Nothing has come. All the courts in Patna, in Delhi, in Allahabad, in Lucknow, all the 10 states, they have all got the stay order.
But
and
only one High Court has given final judgment.
No, I don't agree with that because
you're entitled not to agree, sir.
My lord, I mean, these things which I'm telling you.
Any judgment against you, you should not agree.
Let me.
How can you agree to a judgment which is against you? You should not agree.
Let me.
Mr. Mohanty, you're very senior. But if I were you and somebody gave me like this a judgment, I will tell the court, sir, let me study this judgment and make arguments. But I think you have already decided you're against this judgment.
No, my lord, I will read it.
Normally, I would do that, but you're such a senior person.
I will read it then. Let it come and. But I have. What I have
You've decided you're against this judgment, but without reading it.
I will read it. In view of the importance of the valuation,
No, not here.
I will read it and
read it, understand it, then formulate your arguments and then argue.
Any date.
Very good, very good. Counsel for the respondent has placed reliance on the judgment of a Bombay High Court in practicing values association in India was the State Bank of India. MA/NU/MH/1058/2020 and states the case of the petitioner stands answered against the petitioners by the said judgment. Full stop. He, however, adds that the said judgment is now pending consideration in appeal before the Supreme Court of India. Paragraph. Mr. Mohanty, learned counsel for the petitioner, seeks time to study the judgment and advance arguments. List on. March 2023.
Item number 71.
Made legal reference. This issue is squarely covered by your lordship's judgment. I have given the compilation of the other day. That is, my Lord Chief Justice passed it on 28th of July 2022. And your lordship may kindly see, basing on this, that issue is the 263(2) order cannot be passed beyond 2 years from the financial year in which the assessment order has been passed. That was the issue in that case, and that is the issue in this case. Here, my lords, an assessment under answer 4 for the assessment year 15-16 was passed in December to 18th of December 2017. So the financial year is 17-18. Now, the initiation of the proceeding and also the order should have been passed by 31st of March 2020. Now, what he did, my lords, the commissioner issued the notice. Lordship will kindly see Annexure 1, 26th of February 2021. That is 1 year after the financial year, after the expiry of yes.
You filed a reply or you not?
No, my lord, your lordship has similar issues has already been directed to file appeal on my lord 13/4/2022. My lord, in case of AMS Agro Partners, here my lord, the commissioners taking assistance of the your lordship CD page 18 last para.
Here the initiation itself is illegal. It's void, my lords. Initiation has been made on 26/2/2021 after the expiry of the financial year in which
So they're relying on this corona pandemic.
Yes. No. They have relied, my lords, but now the initiation is when, my lords, they can initiate when the corona was there at the height. Now they could not pass the order.
The Supreme Court said because of Supreme Court.
No. Supreme Court never said that you don't issue the notice. Don't issue the notice when the corona is in full height. Now, Lordship may kindly see.
No, but Supreme Court order is there. They can.
Supreme Court order I have also enclosed, my lords. That is, my lords, Annexure 7 at page 41. Lordship will kindly see. Lordship may kindly see that order of the Supreme Court.
Cognizance for extension of limitation.
Yes. Now, my lords, they have not, this extension was there till September 2020, not beyond that.
No.
Yes, my lords.
So the Supreme Court stay continued, that extension of stay continued much beyond, sir. I think only in 2022 it has been brought to an end.
Extension also there.
Actually, you may want to use it in some other cases of yours. So you be careful.
My lords.
You be careful. In other cases, you might want to use it.
Even accepting, my lords. Let us say. Let us accept it. Let us accept it, my lords, that Supreme Court has extended it.
Correct.
Okay?
All right.
Then, my lords, the notice could have been issued after this corona.
Nobody knew when corona is going to end. Nobody knew when corona is going to end.
No. If the notice has been issued in 26/2/2021, 26th of February 2021, my lords, Annexure 1. Annexure 1 at page 10.
So you're saying no corona, when during corona you could issue notice, for you there is no limitation.
No. Limitation is for the department.
That's what I'm saying. You're telling department, if you have issued notice during corona, no extension of time. You have to finish within 2 years.
It has passed, my lords, it has passed. There should have been, notice should have been initiated, proceedings should have been initiated.
Pre-corona.
Now what they did after corona.
Additional question, sir. Additional question to be addressed. We don't know when. It will be addressed.
I know. Lordship will kindly see your Lordship's own judgment. I don't know about the what orders they have cited.
No, it's only 2-page order. Mr. Satpathy is very kind to you. It doesn't make you read more than 2 pages.
No. I am also very much kind to him, my lords. I am very much kind to him because they are the department. My lords may kindly see page 31 of your Lordship's order.
That's right. That order is there.
Order is there, my lords?
Correct.
There also, the same thing happened.
See, Mr. Mahapatra's stand is not binding on Mr. Satpathy. This is the problem.
But the court will have a parity, my lords. The court will have a parity. It will not discriminate.
Right.
If that order, my lords, has been quashed, and there also no jurisdictional question was raised, and even that also, even though also, my lords have quashed because it is beyond the time limit.
But then Mr. Sarpathi's second matter in April.
Which one?
That's what he's handed over. 2 pages. SM Agro.
SM Agro.
Alternate remedy.
Yes. That is, manners, no deliberation has been made.
No. When it's alternate remedy, we don't want to make deliberation.
Manners, alternate remedy. Manners, make if Lordship may permit me, I'll in the compilation, I'll cite one judgment, which is very much, very often cited before Lordship, that your Lordship may kindly see.
Chabil Das.
Yes, yes. Lordship, I'll para 12. Para 12, that starts 60 to 69. Para 12, Lordship may give me. The constitution benches of this court in case Rashid and Son versus IT Investigation Commission, Sangram Singh versus Election Tribunal versus Union of India versus Burma, State of UP, then have held that though Article 226 confers very wide powers in the matter of issuing writs on the High Court, the remedy of writ is absolutely discretionary in character. If the High Court is satisfied that the aggrieved party can have an adequate and suitable relief elsewhere, it can refuse to exercise in jurisdiction. The court, in extraordinary circumstances, may exercise the power if it comes to the conclusion that there has been a breach of principles of natural justice, I am not there, or the procedure required for the decision has not been adopted, then, my lords, thereafter, my lords, again, my lords,
or defiance in the fundamental principles of judicial procedure.
Yes.
Or has resorted to invoke the provisions which are repealed.
Yes.
So all this.
All this. My lords, here, my lords, the notice should have been issued before 31st of March 2020. Now, while issuing the notice, the commissioner, no, did the commissioner, my lords, did the commissioner, while issuing the notice, has taken the plea that because of the corona, he was prevented in issuing the notice, and therefore the notice is being issued because of the extension of time by the corona?
I think he will start pleading first wave, second wave, Omicron, all that he will plead.
And that could have been done.
He says maybe first wave I was not affected, but second wave I was.
Second wave came in April 2021.
So again, disputed question of fact it will become.
more the disputes, my lords. What my duty is, my lords, to pursue your lordships, and my duty equally is to point out the wrong approach in the decision-making process, because it's a such proceeding matters.
Correct.
Now, my lords, in spite of the fact that, well, what made him to delay the matter, and only in the month of February 2021, he has issued the notice. Is there any whisper? There is no whisper to that effect, my lords. They said that, yes, I am the order because of the corona. And I could not. That is the thing, my lords.
We considered, sir, the appellate authority will consider.
Beg your pardon, my lords.
The appellate authority will consider that.
Then, my lords, I will file the second appeal before the tribunal
Right.
against the order of the Commissioner of Income Tax.
Right.
That is Annexure 2.
Correct.
At page 13, my lords.
Correct.
And lords, since I have been enjoying the stay, my lords,
That will continue till they
that will
pass the order.
continue till the date of
tribunal
the-
passes an order.
Beg your pardon, my lords.
Till the tribunal passes an order.
Yes.
All right. We say counsel for the petitioner seeks leave to withdraw the present petition with liberty to challenge the order dated 18 March 2021 passed by the Commissioner of Income Tax under section 263 of the Income Tax Act 1961 Act before the Income Tax Appellate Tribunal IT in accordance with law. If such appeal is filed not later than
30th of January, my lords, my kind.
1st February 2023, accompanied by an application for condonation of delay, explaining the delay on account of the pendency of the present petition, it could be considered by the tribunal in accordance with law. Till such time, it will stop subject to the appeal being filed within the time aforementioned, accompanied by an application for interim, till such time the ITAT disposes of such application.
Yes.
The interim order passes with this court on
31st of October 2022
will continue.
Balance. And
the originals.
Original annexer.
Correct. Originals be returned subject to being substituted with the attested photocopy thereof.
May I request to target the appeal to be disposed of within
Yeah, only few appeals are there. They are cleaning up. Just like this Aru court. So only hardly hundreds. Now they are now winning the case. Then I told the member, we will find out in the market. Please come and file a case. There is dearth of cases.
Right. All right.
Much obliged.
Right.
Item number 72.
This matter of 2013.
Yes.
26th of March 2013, your lordships are pleased to issue notice with an interim order in my favor, in my client's favor.
Right.
Lordship sees what is the challenge here in the demand issued by the Superintendent of Excise, Annexure 1, page 7. The peculiarity of this notice is, Lord, for the year 2010-11, we have lifted the quantity of, because of the prevalent market situation and its marketability, we have lifted much more than the MGQ fixed. 12-13 again, they have fixed MGQ per the license. Lord, we have also lifted 12-13, whatever they have fixed. Now, Superintendent is calling upon me by this demand that whatever excess you have lifted in 10-11, you must the said excess lifting in 12-13. But unexpected. It can't happen, my lord.
My lord, may kindly see the last para of the impugned order, Annexure 1, impugned notice, at page 7.
Hence, you are hereby requested.
Hence, you are requested to lift the balance quantity of make good the shortfall positively without the so-and-so and end of March to the, or else you will not be eligible to participate in the auction of sub-renewal license 2010. That is already over. They are no more the licensee.
I'm not there. Let them not issue a demand notice.
So that is it. Once demand notice is issued, there is a fresh cause of action you will file. But so far as the impugned letter is concerned, no, that cannot be. That is
kindly see, Lord. Whether can at all issue this order that is March 10-11. Can't happen, Lord. That's not the law.
So by anticipating that demand notice will be issued after disposal of this case, your lordship will say that you cannot issue the demand
This
notice.
cannot happen, my lord, in any stage of imagination.
Why should you whatever they lifted last year, you can't say this year you have to lift that.
No, that is not. Now he is saying
that is what he's agreed by. He says, how could you have?
No, he will not lift it. He is no more a licensee.
No, you make a statement and the question of raising any demand.
Yes. No, demand notice in shape of money because he has not complied the MGQ. Now the
unfortunate man, much beyond that I have lifted. 12-13 I have lifted much beyond.
That is a question of disputed question.
What
of
question
fact.
disputed?
That whether you have lifted or not. Then your lordship will kindly see. Anticipating that a demand notice will come, he will take order from the order.
Not anticipating. I am challenging this order.
Now there is no demand notice as yet. He is the impugned order says that you are not eligible to participate.
He sees that as the next logical step is demand notice.
Demand notice, there is no demand notice.
No. He says from what you have written,
Yes.
he cannot meet this requirement.
No, that is cause of action doesn't survive. To meet the requirement, he is no more a licensee.
No, but it doesn't stop you from raising a demand. That's the only question.
No, that
will you raise a demand on the basis of this impugned letter or not? That's only
thing. A demand has not yet been raised.
It will not hereafter be raised.
That is that nobody knows. Once it is raised,
No, that's why he says instead of coming again and again, let me get to know from here now only whether you're going to issue a demand notice or not.
No, demand notice. Once a demand notice is issued, you can challenge it by saying that it is without jurisdiction because
Mr. Ratha is already giving up his brief. He says, I know I will get one more case when you issue a demand notice, but I'm willing to give it up because I want it to be decided now.
Because why I am so much again, he will come up with another case. Once your lordship will hear that by anticipating that another demand notice will come, he will get an order. Then many people will come in the same line.
With great respect to Mr. Mohan, it's unconscious.
Yeah, that's the end.
It can't happen.
Why multiply litigation?
It has not happened. He is saying it can't happen. It has not happened. This order must go.
Yes,
I don't say, but you cannot take any observation from the anticipating that some demand notice will come.
So, Mr. Ratha, if this order goes, then
nothing remains.
Nothing remains. So, say the impugned order was issued by the Superintendent of Excise, Baleshwar, stating that unless the petitioner, who at that time was a licensee of an IMFL beer off shop, lifts the same quantity as the previous year's single quotes lifting, unquote, he would be proceeded against. He would be prevented from participating in the settlement of the excise shop for 2013-14 paragraph. Although that contingency has now been crossed, the only apprehension expressed by counsel to the petitioner is that on the basis of the impugned notice, no demand should be raised against the petitioner. So it may be mentioned that petitioner has long since ceased to be a licensee of the concerned IMFL/beer off shop. Paragraph. On 26th March 2013, while issuing notice in the present petition, the operation of the impugned communication was stayed, and that stay has continued since then. Paragraph. It is not in dispute that the impugned letter has lost its relevance due to passage of time.
And the shop in question has already been allotted to others.
The shop in question has also been allotted to others. Mr. Mohanty, learned AGA, states that the impugned notice therefore does not survive and he will have no objection to it being set aside. Paragraph. In that view of the matter, the impugned notice is hereby quashed. The writ petition is allowed in the above terms, no orders.
But all these matters are same.
Yes.
Item 73 also is covered by your lordship.
All right. In view of the order passed today in that 72, this petition is also allowed. The impugned letter is hereby quashed. All right.
74.
On behalf of K. Pradhan, Mr. N. Sahani was tired. Your lordship can taken up next to.
Why? Why, sir?
File was misplaced.
File misplaced means we'll give you permission to revive it once you find the file. Counsel, the petitioner states the file has been misplaced. Dismiss the non-prosecution. Liberty to the petitioner to revive the petition if the file is found. Correct.
Item 75.
Infructuous mallet.
Infructuous dismissed.
Item 76.
None appears dismissed.
Item number 77.
Lord, 77 again. Lord, prior to this 2017 rules coming into operation, the earlier rule was Rule 6A with regard to MGQ. And they say that they fix a monthly quota for each license. For this month, beer is this, liquor is this. So accordingly, there was a Rule 6A. that if at all somebody defaults in lifting that monthly quota, it is for the collector to permit to adjust, excess lifting in the next month so that it can be adjusted.
All the period is now over.
Now over, and we have also lifted all entire thing we have lifted. But then what they have done is this calculating the monthly difference, they have collected amount from me. Though I have lifted the entire yearly quota, but they have collected amount calculating the monthly sort lifting. So in humble Lakshminarayan Manti's case covers my point.
Overall in the year you have exceeded MGQ.
I have already deposited that.
Overall quantity.
I am seeking now refund of that. So Lordship may permit me to either approach the government citing the judgment.
I think yes. Counsel, the petitioner is permitted to approach the opposite party state government for refund of any amount which he considers to have been collected in excess from him. If such application is filed not later than 1st February 2020, disposed of by a reasoned order after hearing the petitioner.
May say that no, there is your lordship not observing any.
Within a period of 3 months thereafter, and communicated to the petitioner within a week of the order being passed. The court clarifies it is not expressed anywhere in the matter.
But the government will consider keeping in view to the judgment I have given to your lordship.
That is all.
That will little help to me, my lord.
That is there, they will consider.
All right.
Item number 78.
Mr. Mahanti doesn't consider here. How their government will consider there.
Please, your lordship. But here there is an interim order was passed 10/2017. Pursuant to interim order, my lord, the collector has revised the demand. But I have under Annexure 12, I have filed an additional affidavit at internal page 5, Annexure 12. That is dated 31/7/2019. The collector has directed the revised demand, and I have paid on the next page, Annexure 6. So, my lord, pursuant to order, and they have revised the demand, I have paid the amount.
So nothing.
Lordship may dispose of nothing.
Or in view of subsequent developments.
Lordship, just refer that letter of the collector. Otherwise, they will not.
All right. And
it's 12 at page 5, 31/7/2019 dated.
Okay.
Connected read
and view of the letter dated 31/7/2019 of the collector. Mr. Patra states that nothing survives the present petition. It is disposed of.
But I have deposited. As per their calculation, I have deposited.
He has deposited the amount demanded.
And
therefore, nothing survives. The petition is disposed of. All right.
Item number 79.
Mr. Ratha was here.
79.
Mr. Ratha?
I'm so sorry, Milord. Milord, it's an audit, na? Audit, Milord, the mirror order is to be passed. Yes, 79 and one more matter.
80, 81.
Only 79. Yes. Then 80.
78.
79.
79.
That's covered by the order. Milord, I have proposed certain correction.
Correct.
80.
Item 80.
88.
Interchangeability, again, mirror order, Milord. I am giving.
Mirror.
That's 80.
The order. 80 and 81.
The grievance of Mr. Ratha is that his chamber is now going to be totally.
No, I was just talking. My excise rack will fall vacant, man.
Now rack falls vacant, sir. They will come up with a new policy. Rack will again develop.
I'm waiting for March then.
Only 1 month.
All these infrastructure cases.
Racks. Only hard drives. He says now after technology. You don't need for racks, only hard drives you need.
Yes.
Scanned copies.
He's a technosec man. So,
in fact, your office should become paperless.
Lord, in fact, I'm little backward there, Lord.
No. You are backward enough.
I am to educate myself. How in fact, your lordships are managing with. I am to educate myself.
Yes. You please come. You any day.
But the way I
open to the bar. Any one of you wants to come.
How is the lot is looking at that page number, paragraph on that board?
You can easily do it. Just ask Brother Raman. It's very easy to
very easy.
You will find it very easy.
I think you are the first person during the corona appearing.
Yes. I used it. Computer appearance and yes, I did that.
So this is for which one? This
My lord, this is the
item
80.
Ah.
80 ପାଇଁ ଦେଲ ତ ସେଇଟା।
My lord, this is for 80 and 81.
80 and 81.
and 80.
Okay.
Item number 82.
82. Viraja Prasad Das.
My lord, item number 82, infructuous.
Infructuous dismissed. All right.
Thank you.
Item number 83.
Covered.
Covered.
Ah.
Covered.
Correction.
All right. All right.
Item number 84.
84, my lord, there are previous orders. In last occasion, Mr. Mahanti issued us that they will issue us the license because taking help of a civil dispute between the co-sharers, the on-shop cannot be rejected. And matter is pending for the, in fact, Mr. Mahanti took time last date that is appearing in the order dated 28th of October 2022. Para 3.
Your Lordship may direct that within 3 weeks we will take a final decision on the proposal of the petitioner.
Cannot. Yeah. Mr. Mohanty states that if a time-bound direction is issued, the decision of the collector Khurda will be made available to the petitioner.
No, collector, your Lordship may say government because collector will take and recommend the
Yes,
commissioner.
government or the government's decision made known to the petitioner as ordered. Paragraph. It's accordingly directed that the final
decision on the proposal of the petitioner
final decision
for grant of on-shop license
of the collector.
Proposal of
collector is yet to make a proposal.
Collector
will give the proposal as commissioner. Then it will go to the government and government will grant the license. This is the
Direction is
procedure.
issued that the collector Khurda will make his recommendation to the
excise commissioner
not later than when 1st February.
My lord,
1st February.
No, within because what I know that within shortly we will give it.
Okay.
Collector
Not
will
later
give it
than
to
9th
excise commissioner.
9th January.
9th January.
9th January.
9th January.
Then excise commissioner
The final decision of the government thereon will be communicated to the petitioner within a period of 4 weeks thereafter. Not later than 4 weeks thereafter.
My lord, that recommendation need not be sent to the copy and petitioner.
No,
it
no,
will
no.
be official communication.
No, the final decision.
Final decision.
That's,
Yes.
Right. No further directions are required at this stage. The petition is disposed of.
Yes.
Item number 85.
My lord, in this case, the government has already granted the passed the order. I have given the order copy.
Government has passed the order, license is yet.
Yes, government has passed the order approving the proposal for conversion. Now order will be issued by the collector, license will be issued by the collector.
Let me suggest, let it come in the first week of reopening.
All right.
In the meantime, they let them complete their procedure.
My lord, why to keep it pending? Within your lordship may record that pursuant to the government's order, the appropriate authority will issue the license
Mr.
within 10
Mahanti
days.
States that the government has already issued the orders approving the proposal
for conversion of the beer parlor to
conversion of the beer parlor to
on-shop.
Yeah. He states that the consequential issuance of license will take place not later than 9th January 2023. The petition is accordingly disposed of.
Lord, in the previous matter, can I just put a small request, madam? The previous matter, item 84, while passing the final order, they will also take into consideration the order dated 9th of September 2022 passed by this honorable court. There it is observed on merits, the observations are there.
There are some observations by the honorable court.
That also
this cannot be ground to reject this.
Okay, final order will be passed, taking note of the orders passed in this court in the present petition. All right.
Dated 9th of September 2022.
All the orders will
yes.
Great passed order.
Sure.
Weekly list passed order matter item number 9.
File an interim application for restoration. Though due time this application was filed, but I filed memo matter not come
for hearing, Lordship.
What's the main matter about, sir?
Main matter is under Odisha Government Land Settlement Act, Lordship. The petitioners are the landless. They file an application before the Tahsildar concerned for settlement of government land in their favor. Where the inquiry was conducted after following due procedure of law, land was allotted in favor of the petitioners in 2000. In 2003, the ADM, the opposite party number 2, so much initiated proceeding, OGLS revision, and fresh report called for the RI concerned as well as Tahsildar. Thereafter, cancel the settlement order. That order challenging the original application before the Honorable Court. The only ground is
the file is not with me. The miscase file is only available with me. The read petition file is not. Can I get the file?
Sure. It's at the request of Mr. Manthi, list this petition.
My lord, the restoration may be allowed. It may be posted for hearing before in the
It's the 2003 writ petition, sir.
Oh, I'm sorry. I'm sorry. No, I can see the file right now and answer the question. Definitely.
the revisional authority taken sole ground that the land in question, the earlier settled in another person in 1977. That is a mistake of fact. That is on ground. Taken in the order sheet.
The counter has not been filed in this case, but it's too late.
Counter is there. Counter is there.
Counter is there.
There.
Opposite
Counter
party number
there.
2 and 3.
Oh, I'm sorry. Yes.
Counter there.
Oh. Let me place the counter.
In fact, no rejoinder has been filed.
Yes, no rejoinder. The ADM has exercised its jurisdiction under section 7A3 of the OJLS. Cancel the lease.
Lordship, page 24. They stated in that the land is settled in the favor of the petitioners. The schedule also given.
No, it's somebody else is in possession.
Somebody else, you are not in possession.
Para 7, come to para 7 of the counter.
Yes, my lord.
Counter the stated there somebody has possession. But if Lordship call for a report, nobody would
That is based on RI report.
There's no rejoinder filed. Why should we call a report?
That is based on RI report. In the
petitioners are
inquiry
possession
is
of the
conducted
property.
by the RI.
These are all disputed questions, sir. We won't enter it into it at this stage. You see, for the reason stated, the application is allowed, the order is recalled, and then the main writ petition, it is restored today. First order passed in the CM APL. The prayer in the present petition is that an order dated 30th April 2003 passed by the ADM Sonpur in OGLS revision number 2 of 2003 should be quoted. Paragraph. While issuing notice in the present petition, payback on 4th October 2004, status quo is asked to be maintained by this court. Paragraph. In response to the petition, it has been averred in para 7 of the counter affidavit. As under, just reproduce all of para 7. It is clear that if we stop, there has been no rejoinder filed to contradict any of the above arguments in the counter affidavit till date. Full stop. Paragraph counts for the petitioner seeks to assert that the petitioners are in possession. Full stop. However, this only gives rise to a disputed question of fact, which in any event cannot be examined in the present writ petition. Paragraph. Consequently, this court is not inclined to entertain the present petition, and it is dismissed as such.
Lordship, on the small prayer in the order, the revisional authority also further direct the Tahsildar concerned to consider the case of the petitioners in allotting the homestead if they are eligible. That part already there in page 29, last 4 lines.
So that will be there. We only
Lordship,
discuss the petition. We're saying we're not interfering with that order. That will be there. All right.
Pastoral matter item 48.
I am for the petition, my lord.
Yes.
My effective respondent is, my lord, respondent number 1. Upon him, my lord, I have served personally, my lord. This is the service record, my lord, I am providing. And the issue in this case is covered by your lordship's judgment, my lord, in Bright Stars case. On 29th November, my lord, I have served.
My lord, no copy has been served on me. It is only served to the and the opposite party number 1.
My lord, I am serving it in the court, my lord, kindly exempt from the service, my lord.
All right. Serve it too.
Yes.
A copy of the petition has been handed over to Mr. Sunil Mishra and counsel, standing counsel for the department today in court. He needs extensions. List on.
Well, one small request, my lord. My junior, my lord, missed to file the IA, my lord. So, my lord, liberty may be allowed to file the IA.
There's no liberty, sir. You can always file an IA. Who's going to stop? List on 12 January. Right.
I will be grateful, my lord, if it is fixed in the last week of January, my lord.
Oh, one later. 31st January.
31st, any day.
1 minute. 1st February.
Yes, I'm grateful. 1st February. I'm grateful.
Item number 64.
Your lordship, in this case, at the beginning, I may be permitted to draw your lordship's attention. Your lordship, otherwise, I am ready, your lordship. Your lordship might have remembered that those IOCL exemption matters, your lordship. Your lordship, those matters have been, your lordship has fixed all those matters on 12th April 2023. So your lordship, if your lordship will
wait,
adjourn this matter to that day, or your lordship, please.
He will not have a problem because he's got a stay in his favor.
Your lordship,
he has a stay in his favor. No?
No, I have no problem. If my friends think it's only like
I'm not trying.
Okay, what's the number? What's that number?
Your lordship.
But only
difference is that in those cases,
big difference.
Then your lordship may hear the matter. Your lordship, I'm worried about if any observation will be here, then that may affect in those cases.
All right. List along with petition civil 1259 of 2012 on 12th April 2023. Interim order to continue.
Obliged.
All right.
Obliged.
Over. All right.